Okay, members, I call the meeting of the Property Tax and Local Government Finance Division back to order. Members, welcome back from lunch. We are going to begin with an overview of the division report, and then we will move the bill and begin amendments and go from there. But we'll start with Mr. Hines. Do you want to start, or I don't know who wants it. Actually, Mr. Clayman is going to start, members.
Mr. Chair, members of the committee, so we'll just do a walkthrough here through the A18-0818 Delete Everything Amendment. That's this year's Property Tax Division report. The first article is Article 1, Property Taxes. The first section is the Agricultural Historical Society property exemption, and that is slightly different than how it was heard in committee. It's down to 40 acres, and I believe it was 50 acres when it was originally heard. Section 2 is the exemption for licensed child care facilities. That has also been changed slightly from how it was heard. The exemption has been modified so that it applies to licensed facilities that are operated by a church organization as part of its mission. So that was new language that came in after the hearing. Section 3 and 4 are the Representative Anderson's bill regarding business entities and how property owned by, or agricultural property owned by two different business entities can, under certain conditions, be linked together for ag homestead purposes. One key difference in how that appears in the division report versus how it was heard in committee is that the familial relationship requirement was narrowed from requiring third degree of kindred familial relationships to second degree of kindred familial relationships, which takes it from the great-grandfather level down to the grandfather to grandchildren level. Section 4 also includes provisions related to property owned or agricultural property owned by two different trusts. And this was a bill from that this committee heard in 2017. I believe it was a Knobloch bill. And that does something, or what that provision does is it allows property owned by two different trusts to qualify for ag homestead under certain conditions. Namely, the two trusts, the grantors of the two trusts are typically spouses, or one is a surviving spouse and the other is a deceased spouse. And that also carries over into Section 5, that the Knobloch Agricultural Homestead for Trusts bill. Section 6 is another provision from last year relating to homestead resorts. And that allows property that's owned by, or well, that allows a homestead that's titled in the name of an owner of a business entity that owns a resort to qualify for resort homestead status. And that was a provision that this committee heard last year as well. I believe that was a Representative Bliss bill from 2017. And then I think I'll pass Section 7 over to Mr. Hines.
Thank you, Mr. Clayman. Mr. Hines.
Mr. Chairman, Section 7 is two different changes in the classification of agricultural property. One is a bill of Representative Hertas, which allowed that if a parcel of property had 3 acres or 10%, whichever's lesser, I think. It says greater in the sum, I think it's actually lesser, to be could be used for environmental purposes such as buffer strips or retention ponds, and the property would still qualify as agricultural. And then there's a second provision in there that came from Representative Clark Johnson's bill dealing with this particular constituent of his that have a farm with a bad situation with regard to erosion and wanting to construct a holding pond and worried about losing their ag classification. So there's a specific piece in there that's aimed directly at that, narrowly at their situation, that would allow them to retain their ag classification. Section 8 deals with, this is the bill from Representative Gruenhagen regarding craft houses. That bill came in as a, putting them in with the bed and breakfast classification, and after some negotiations, now it's been changed to instead put them in the resort classifications, to conduct indoor craft activities. Section 9 is Representative Bliss's bill that would allow gas pipelines in certain circumstances to be excluded from the state general levy for 12 years. These would be ones that were serving areas that have lacked access to natural gas up to now, just for new systems.
Mr. Chair.
Thank you, Mr. Hines. Mr. Klayman.
Mr. Chair, moving on with Article 1, Sections 10, 12, 13, 14, and 15 all relate to Representative Bennett's bill regarding abatements of the state general tax for certain qualifying medical facilities. One change there is that the federal reference under which the underserved areas are defined was changed to include, to switch from defining it according to health professional shortage areas to medically underserved areas. Section 11 is that's a bill relating to tax forfeiture and the manner in which the Commissioner of Revenue can turn over a deed after a tax forfeiture sale. And that allows the deed to be provided to the county while the closing process is still undergoing, instead of having to wait until after the sale is closed to transfer the deed. And then I'll turn it over to Mr. Hines again here.
Thank you, Mr. Hines.
Mr. Chair, sections 16, 17, and 18 are Representative Detmer's bill, which would allow an agricultural preserve to terminate immediately if the property was being purchased by a public entity for park or trail purposes. Section 19 is a provision that extends the levy authority of the Northwest Minnesota Multi-County Housing and Redevelopment Authority by 5 years. Was going to expire in pay 19. Now it expires in pay 2024. Moving on to Article 2. Article 2 consists of two bills from Representative Whalen that are spurred by the Property Tax Working Group report from 2012. House File 3276, which was the residential classification reform, and 3277, which was the changes in the calendar of property tax deadlines and events. And I think maybe rather than go through that section by section, although we can do that if the committee would like us to, because they're the two bills are intertwined, and Mr. Klayman can speak better about the one and I about the other. I think as far as, if I could speak first to the residential reform piece, there's a table on page 9 and 10 that sort of summarizes best what that bill does in terms of classification labels and class rates. And it's basically that the changes from the original bill that was brought forward is that this bill, this proposal now has dropped the inclusion of non-commercial seasonal recreational property into the residential classification. So non-commercial seasonal recreational, the one we usually refer to as cabins, are no longer brought into the same classification, and they'll retain their separate classification. They'll continue to pay the state general levy. That was a big cost item in the original bill. So that's a change. And then the other change is that bed and breakfasts are kind of being treated differently under the proposal in that some of the bedroom units are being included with the residence homestead. And in the original proposal, the idea was to just include 2 units with the homestead as part of the homestead, and now that's been expanded to put 4 units in with the homestead. Other than that, it's pretty much that bill as originally brought forward. And like I said, there's been a little bit of change in some of the nomenclature of the classes. And if you look on the table on page 9 and 10, the italicized things are what have changed. And you'll notice there hardly any classes have a different class rate. They're almost all the same. A few of them maybe get a small break, like particularly the 4B1 classification, residential non-homestead 1 to 3 units. It's really 2 to 3 units is mostly what it is there. They do get a break from 1.25% on their first 500,000 to 1%. That's duplexes and triplexes primarily. And then in the class 4, there's been some sort of consolidation of classes, but by and large, they've all retained the same class rates that they have now. The B&B is the main sort of change, and even that's not as big a change as it was before. So I think I'll leave that at that. Obviously, we'll take questions, and Mr. Klayman will talk to the calendar parts of the.
Thank you, Mr. Hines. Mr. Klayman.
Mr. Chair, members, I think I would just highlight the only change from the other property tax reform working group bill that Representative Whalen brought forward and amended in committee, and that's in section 33. The senior deferral application deadline in the initial bill was moved actually from July 1 to, I believe, May 1 in the bill that was heard in committee, and that has changed in this version. The deadline moves from July 1 to November 1, and that conforms that date change with the date change that was in the Petersburg senior deferral bill, which is in Article 3. And Mr. Chair, I think we'll move on to Article 3, the aids and credits article. So Section 1 is that Representative Petersburg bill mentioned earlier regarding senior deferral. That's significantly different from how it was heard in committee. The only provisions from that bill that were kept were the provisions relating to the due date and the pre-application language. There's also some additional language that requires the Commissioner of Revenue to state the reasons for an application denial and just remind the senior deferral applicant that they can amend and resubmit their application prior to the new deadlines stated in that provision. And I think I'll turn it over to Ms. Dalton for Section 2.
Thank you, Mr. Klayman. Ms. Dalton.
Mr. Chair, members of the committee, Section 2 actually deals with 2 bills that were introduced, one by Representative Hansen, one by Representative Mary Murphy, dealing with one-time payments, $97,000 to the city of Hermantown, and Representative Hansen had asked for $150,000 to the city of Lilydale to help with sewer costs. That's been turned into $25,000 a year for 6 years, which is identical to what we did for the city of Mendota for a sewer project in the past. Sections 3 to 6 are essentially House File 4403 as amended. However, the language has been modified, so we're referring to undocumented aliens and using the language that and definitions that are used in the IRS tax code. Section 6 relates to Mille, and I will let Mr. Klayman describe it.
Thanks, Ms. Dalton. Mr. Klayman.
Mr. Chair, members, Section 6 is the Mille property tax abatement bill that was heard in this committee in 2017. It's substantially the same as when it was heard. There's one change in the qualification requirements, which moved in the version that's in the division report from requiring documentation of a 5% reduction in any 2 successive years since 2010 to documenting a reduction of 5% in between any 2 years since 2010. And I can go through the subdivisions of that provision in more detail if the committee would like, or just turn it over to Ms. Dalton.
Thank
Do
you,
that
Ms.
for
Dalton.
now.
Mr. Chair, members of the committee, the last section in that article is a repeal of the extra aid paid to the city of Minneapolis to pay library bonds. The summary and the bill actually has the wrong effective date. It should be effective with aids payable in 2018, and that will be included in the author's amendment. Article 4, a lot of this was included last year in the Property Tax Division report. It is not the Property Taxpayers' Bill of Rights, but it deals with requiring counties, cities, and school districts to hold their referendum related to property taxes, debt, and spending on the first Tuesday, either of the first Monday in November of an even or odd year. In 2017, a law passed in the elections bill that limited all elections, municipal and school elections, to one of 5 dates. And so that remains true for any elections not related to property taxes, debt, and spending. The main provisions are actually in sections 2 and 3 as it relates to that. The other 2 bills that are included in this article are section 4. This is Representative Vogel's bill, House File 1146, basically requiring a public notice, hearing, and reverse referendum in the case of a franchise fee that is covering more than just the cost of providing the utility services linked to the utilities. And then Section 7 is Representative Runbeck's bill, House File 112. And this provides a reverse referendum when a city, excluding a first-class city, enters into a lease of 3 or more years for real property with an HRA, Port Authority, or Economic Development Authority as a way to kind of get around bonding requirements. That's pretty much all of that. All the remaining sections in that are really dealing with special laws or one-time, referendum issues dealing with just like one individual city or county. Section 5, our miscellaneous section. Sections 1 through 5 and 10 were in last year's bill. This is Representative Drazkowski's prohibition on spending on the zip rail, and the language here is the language that was in the conference committee report as it came out of conference committee. Sections 6, 7, and 8 and 18 are a repeal of the political contribution refund program. Section 9 is Representative Sarah Anderson's bill requiring Hennepin County to share a portion of its local transportation tax with Maple Grove and the city of Plymouth. Section 11 is Representative Garofalo's bill that allows district heating projects owned by for-profit entities to also qualify for the bond allocation. Sections 12 and 13 are the St. Cloud liquor and food and lodging bills that were heard here, and they went in as amended in committee, and it does require a general approval at a general election before the city can increase these taxes. Section, I'm going to defer to Mr. Clayman at this point for the TIF.
Thank you. Mr. Clayman.
Mr. Chair, Section 14 is the Minneapolis Upper Harbor TIF in North Minneapolis. Representative Lee bill, and then Section 15 is the Champlin TIF for their Mississippi Crossings District, the Representative Uglum bill. And Section 16, I will go back to Ms. Dalton.
Thank you, Ms. Dalton.
Mr. Chair, Section 16 cancels $3.4 million of a balance in one of the Department of Revenue accounts back to the general fund, and the balance is in the local sales tax administrative account. Section 17 appropriates $5,000 to the city of Mazeppa and to Wabasha County in total to deal with property tax abatements and other costs associated with the fire on March 11th, 2018. And as I said, Section 18 is part of the repeal of the political contribution refund program.
Thank you, Ms. Dalton, Mr. Klayman, and Mr. Hines. I'm getting some people that have questions at this point, but we're going to ask Ms. Schill to go through the spreadsheet first, and then we can move to member questions and amendments.
Mr. Chair and members, you have a 3-page spreadsheet in front of you with respect to this DE amendment to House File 465. I've listed changes proposed by the A18 DE amendment. And so we can start with lines 1 through 3, we have a summary. Line 2 identifies the total amount of changes to the February 2018 forecast. In fiscal 18 and 19, the sum of the changes is a negative $11,676,000, and in fiscal 2021, you'll see a negative $10,546,000. Now, as you look down the spreadsheet, we've got it grouped into different categories. Property tax refund impacts, you'll see beginning on line 12. Lines 14 through 18 identify Representative Whalen's bill with respect to the property tax classification consolidation. The total, you'll see a number of different PTR interactions. The total of all of that is reflected on line 18. The impact is in the tails, specifically in fiscal 2021, with a positive spending of $6.63 million. Line 19 through 22 is Representative Anderson's bill with respect to homestead classification requirements for business entities. That also has an impact in the tails. For 2021, it's $660,000. You'll see a number of items that have negligible impact, and let me remind you that negligible means an impact of less of $5,000. And so Representative Knobloch's bill, 610, on lines 23 through 26, have an overall negligible impact on both property tax interactions and an interaction with the agricultural homestead market value credit. Similarly, you'll find that with House File 2372, Representative Johnson's bill, reflected on lines 27 through 30, negligible impacts in the tails. Line 31 begins property tax changes. Representative Bennett's bill is on lines 33 through 36. This is the medical facilities in underserved areas. Let me remind you that this is the property tax impact only. There'll be a sales tax impact that will be reflected in the tax committee. But the property tax impacts of this provision are in the tails only, and it's a small amount, $24,000 in impact to the state general levy. Representative Bliss's bill is lines 37 through 40. This is property exempted from the natural gas pipeline distribution system. Once again, the impacts are small and in the tails, $10,000 state general levy. Representative Bliss's bill on line 41, having to do with the mom and pop resort qualifications, changes in ownership. The impact is $10,000 in the tails. Line 42 is Representative Whelan's bill. This is part of the changes in due dates, and the reason why it's on this sheet is that there is a senior deferral impact that is just beyond the forecast window. The change of the date or the effective date in 2020 has an impact on property tax refunds, or not refunds, the amount that is deferred, and it will have an impact in the year 2022. Representative Gruenhagen's two bills on line 4344 each have a negligible impact, as are the various number of bills on lines 45 through 51. As we move to property tax aids and credit changes, you'll see that Representative Erickson's bill is a little different fiscal impact than when we saw it last in last year's division report. The overall impact in fiscal 2019 includes local property tax abatements at $1.1 million, state general levy refunds at $300,000, and an income tax interaction at -$50,000 for a total of $1.35 million. Line 61, Representative Hansen's bill, the label on this is incorrect. It was changed in the division report to span a period of 6 years. So that Lily Dale adjustment will be $25,000 per year over a period of 6 years. The next item with an impact is Representative Drazkowski's bill with the Mazeppa fire remediation aid at $5,000 in fiscal 2019. I skipped over Representative Murphy's bill, the Hermantown aid adjustment. That's actually $97,000, but it's within the LGA appropriation, and so you'll not see a change in the overall spreadsheet for that. The repeal of the Minneapolis library aid effective in 2018, fiscal 2019. You'll see the reduction there of $4.12 million in 19, and then a little bit less in each year of the tails. The savings from the repeal of the political contribution refund is on line 69, $5.5 million in 2019 and $10 million in the tails. And lastly is on line 70, the transfer from the special revenue fund of $3.41 million in fiscal 18 will be transferred into the general fund. The total impact of changes is reflected on line 79 with, once again, a savings of $11.676 million in fiscal 18 and 19, and once again, a savings of $10,546,000 in fiscal 20 and 21. And on page 3, you'll have a summary of the remaining number of bills that do not have any impact to state fund. And then it's on line 100 through 103 is a housekeeping matter just showing the transfer from the special revenue fund to the general fund of that DOR service and recovery fund.
Thank you, Ms. Schill. Okay, I think we'll go to member questions, and then we can move the bill and the amendment and begin taking testimony, et cetera. So questions, we have Representative Hertaus.
Thank you, Mr. Chair and members. I guess I would direct you to this bill summary document. If you could please turn to page 9. We were discussing one of the changes with regard to residential non-homestead 1 to 3 units. Mr. Chair, I just noticed as we're looking here, if you look right above 4B1, there is residential non-homestead 4+ units has a rate of 1.25%. But then right below it, 1 to 3 units has a rate of 1% for 500,000 in value, and then 1.25 over 500. So my question, members, is if you had a 4-unit residential non-homestead unit that was valued at 300 or 400 or 200,000, it's taxed as a higher rate than a residential non-homestead, the very same use, at 500,000 at 1%. So it would seem logical that 4A should be eliminated and collapsed into the 4B1.
So, Mr. Hines, do you have any comments on that, or Representative Wayne? Mr. Hines?
Mr. Chairman, I would just say that, you know, these tables tend to get replicated, and, you know, normally we would call 4A apartments, and we would not call it residential non-homestead, so that may be a little confusion. But that, you're right that there has been and then really the 4B1, it says non-homestead 1 to 3 units, but it's really that line, I would tend to refer to that as 2 to 3 units, because if you look further down, you'll see 4BB1, residential non-homestead single unit. So the 4B1 is really more to think of as duplexes and triplexes. And those, so the duplexes and triplexes and the 4A apartments are really all at the 1.25 now. Under the proposal, however, the duplexes and triplexes would go to the 1% on the first 500. And that's a historical distinction that's been made by the legislature between the 4 or more or the under 4.
Thank you, Mr. Hines. Representative Hertaus?
Thank you, Mr. Chair and Mr. Hines. Thanks for that clarification. I guess in the end, they're all non-homestead and they're all residential use. And this certainly would be something that we should be looking at.
Thank you. Representative Loeffler?
Well, thank you, Mr. Chair. And the reason, as I recall, why this was created the way it was I think actually in reaction to a court case long ago about lifting a limited market value or something or other. And the situation, as I recall, was that the small-scale rental properties that were designed to be rental, the duplexes and triplexes, I have thousands of them in my district. It's probably about, I don't know, 40, 50% of my housing stock because the era when my area was developed. They are valued by comparable sales. And so it used to be 40% were owner occupied. Their value was more based on what people were willing to pay in the market for that as housing, where my understanding was that the larger apartment buildings tended to be a rent capitalization approach to valuing, and so that's why there was a distinction in terms of classifying the properties. I don't pretend to be an expert on real estate and values and how they get set. You probably know much more than I do about this, but they really do operate in different ways. The single family that's rented being pulled out was a newer change, and quite honestly has caused some consternation in communities that have seen a lot more investors competing with people who want to become homeowners and turning single-family homes into rental. And so there's a thought that they should be treated the same as any other rental property, whether it's a duplex or a single-family home. But my understanding is that there's still that distinction in terms of how they're valued, and that's why there's a separate category for them. And so I think we should be thinking carefully about what the impacts would be if we change that. And I think I prefer the name apartments, as Mr. Hines said, because actually most of the properties that are in that category are not the fourplexes. They're they may be the 100-unit buildings or more, or 10 or 12, 3-story walk-up apartment buildings, that sort of thing.
Thank you, Representative Loeffler. Representative Hertaus?
Thank you, Mr. Chair, and Representative Loeffler. I agree, there's 3 ways you value property. It's income approach, the market approach, or the cost approach. And rent capitalization is part of the income approach. And whether they're apartments or not, and I won't belabor this any longer, but nonetheless, with regard to apartments, after the $500,000 value, it would have the higher rate. So we continually talk about compression and simplification, and this is one area that we should certainly look at in the future. Thank you.
Thank you. Any other questions about the kind of the walkthrough of the bill, members? And then maybe we'll get the bill before us, and then we can take testimony and questions will follow as well. With that, I am going to move that we adopt House File 465 and that it be referred to the Taxes Committee. And with that, members, we need to adopt then from that and amend into it the A18-0818 amendments. So I move that we amend House File 465 by adopting the A18-0818 amendment. Discussion on the motion to amend. Hearing none, all in favor of adopting the A18-0818 amendment signify by saying aye.
Mr. Chair, I have a question.
Representative Erickson.
If you would if we adopt the A18-0818 amendment, how can we amend it? Aren't you just moving it?
I am moving it to amend the House file, Representative Erickson, and when it's amended, we can still amend, we can still amend the amended bill. Or we'd be amending an amendment, so either way can be complicated, so.
Okay, I just
Okay.
want to make sure we're doing this correctly.
Okay.
Thank you.
Thank you. Other discussion on the amendment? Hearing none, all in favor of adopting the A18-0818 amendment signify by saying aye. Aye. Opposed, no. Motion passes. The amendment is adopted. So before us, we have the amended House File 465, which is the division report as it was presented and reviewed by the committee. We have the First Amendment. We do have an author's amendment that staff has put together, some technical corrections that need to happen in order to get us into the best shape forward, going forward, and that is the A18 Amendment. And the A18 is coming around, members, so we'll wait until it comes around.
I don't know how many you guys got.
Okay, the chair moves adoption of the H0465A18 amendment. Discussion on the amendment. Hearing none. Oh, Representative Loeffler.
Well, thank you, Mr. Chair. And the last line of this addresses a point of confusion. And since you weren't available yesterday, we weren't able to deal with that. And that is in the underlying amendment we just adopted, you proposed deleting the Minneapolis Public Library Aid, which was established by the legislature years ago to recognize the fact that the downtown Minneapolis Library, operated by Hennepin County, is a statewide resource. In the bill, it said that it would be effective in 2019, and in the spreadsheets, it appeared that it would be effective in fiscal year 18, which is our current fiscal year. So a $4 million cut in the middle of the year to our city is the equivalent of an $8 million cut in the budget. And you can imagine, no matter what the size of your city, that's a lot of people on payroll. That's a lot of potential public safety equipment and other things that our city will have to wrestle with. And I don't think it's in good faith for the state to back away from an agreement, because it was put together because every single one of your constituents or at least someone in your district has probably used the resources of the Minneapolis Downtown Library. It has the largest nonfiction collection in the state that's available to the general public. We used to have, I don't know how many we have now, we used to have 2 people full-time who did nothing but pull books off the stack to send to people across the state of Minnesota through the interlibrary loan process. As you might know, nonfiction books are the most expensive. Access to the databases for research are very expensive, and this makes it available to library users throughout the state of Minnesota. We also have the state's only patent library. And so anyone who is looking to do patent or trademark search because they're starting up a business, it doesn't matter in which of the 855 cities in Minnesota, they can get a hold of our downtown Minneapolis library and have them do the research. They have all the records on the patents that have been offered. It wouldn't be cost effective for our state to have these kind of resources duplicated across our state. It's very cost effective to have one central library that meets the needs of people across the whole state of Minnesota. And so the state had agreed to contribute part of the costs of financing that library to update it. And so I am concerned about not only the precedent of backing away from a commitment on which our decisions in Minneapolis were based, but also in doing this mid-year, in the middle of a budget year. Many of you I know have been local government officials. You know how difficult it is in the middle of a budget year when you've made commitments to have this large of unexpected item come up, and it was not heard as a bill in all of our hearings this year. And I respectfully think we need to rethink this one. But this amendment makes it clear that we are to be subjected to the city of Minneapolis would be subjected to this in the middle of a budget year without warning.
Thank you. Other questions or comments on the amendment, members? Hearing none, all in favor of adopting the A18 amendment signify by saying aye. Aye. Opposed, no. Motion passes, sorry, premature. Motion passes, the amendment is adopted, the A18. Okay, I think we've got some people who would like to testify on the bill. If you'd like to testify, please come forward. You can start at the top of the list here. Ms. Carlson, are you here? There she is. Welcome, Ms. Carlson. Please introduce yourself for the record and proceed.
Thank you, Mr. Chair and members. Good afternoon. My name is Jan Carlson. I am Chair of the Hennepin County Board of Commissioners, and I continue to be opposed to provisions in this bill that would negatively impact transportation funding and local control. Article 5, Section 9 includes language that would overrule authority granted to all Minnesota counties to impose a sales tax to fund transportation needs, and it would specifically target Hennepin County. I clarified previously for you some of the inaccuracies that seem to underpin this legislation, that the bridge over 494 at County Road 9 in Plymouth is not our bridge, but yours, that the condition of the bridge has been evaluated and rated by MnDOT, that the representations being made by Plymouth and Maple Grove about our historical investment in their communities are incorrect, and that we believe our process of prioritizing road and bridge investments is fair. Today, I prefer to concentrate on some of the implications of this legislation. I am sure Plymouth and Maple Grove are correct when they assert that they pay more into Hennepin County than they receive, although I am sure the same can also be said about what they pay to the state of Minnesota and the federal government. As you consider this legislation, then, please ask yourself how you can distinguish Plymouth and Maple Grove from any number of other communities, cities in your jurisdiction perhaps, which pay in more to county government than they receive back. And how will you respond when they ask for similar legislation? Please ask yourself what your message is to smaller communities, which, unlike Plymouth and Maple Grove, will never have the tax base to pay to have their wants moved up in line. Many smaller western Hennepin County communities are in this category. And then ask yourself whether you agree with the fundamental assertion by Plymouth and Maple Grove that their success is uniquely the result of their investments and their leadership. These two cities have benefited from a strong regional transportation network, including historical investments made by the state and Hennepin County in roads and bridges, both in these communities and in the region. Much of the sales tax and tax revenue in general that they claim as theirs is undoubtedly the result of folks traveling to Plymouth and Maple Grove from neighboring cities over county roads or state highways for jobs and shopping. The fundamental question then for you that this bill presents is whether the Plymouth Maple Grove assertion that what's ours is now the organizing principle for transportation funding in this state. If it is, then, as I said at your previous hearing, I trust that the state will apply it consistently to Hennepin County and return some of the $84 million in funding that it collects annually from Hennepin County and redistributes elsewhere, not to mention the $15 million collected through the leased motor vehicle sales tax from which Hennepin County is excluded. We'll be able to meet more than the road needs of Plymouth and Maple Grove once this new principle is fairly applied. A month or so ago, I was asked to attend a meeting relating to this bill. At that meeting, a Senate committee administrator made clear to me that, unless we get on board with Plymouth's request to fund the state's bridge, we could expect a chilly reception for our bonding requests. Now, we only have one bonding request, and that is for the Regional Medical Examiner's Facility, along with Dakota and Scott counties. So the administrator added that perhaps a Hennepin County city would not get funding for a project that could be important to Hennepin County. When I asked for an example, the committee administrator referenced a suburban community which apparently has submitted some road requests. And so my final question for you is whether the power of the state of Minnesota is to be used to coerce a local unit of government to pay to fix a bridge that it does not even own. I hope that this is not where we have now moved as a state. Thank you for the opportunity to speak.
Thank you, Ms. Callison. Members, any questions for Ms. Callison? Thank you. Next, we have a bunch of people that would like to speak to the content of this bill. Mr. Keller. And in the interest of time, folks, let's keep it on the content of the bill.
That's not in the bill.
Mr. Keller, welcome. Please introduce yourself for the record and proceed, sir.
Thank you. My name is John Keller. I'm the Executive Director of the Immigrant Law Center of Minnesota, and I testify today against the amendments. Hold on. Sorry, one second. The previous hearing 2 days ago, I testified regarding the legal defense fund language, so I won't testify to that today. Today, I'll concentrate my comments around the anti-sanctuary language of this amendment. It's bad for local communities, bad for local law enforcement, and bad for Minnesota. The bill forces law enforcement agencies, excuse me, in Minnesota to do the work of the federal government in the enforcement of civil immigration laws. It imposes heavy fiscal consequences and liability on law enforcement agencies who do not comply with the proposed state laws. And the bill will cost local communities thousands of dollars that could be better spent on issues of local concern. The bill sets up an impossible choice for local communities: comply with the new state law and open themselves up to liability for holding somebody against their constitutional protections to be free from incarceration without probable cause. Or you could follow the countless federal rulings and the U.S. Constitution and risk losing local government aid. This bill, in short, will be a litigation smorgasbord, a full employment plan for a wide range of civil rights plaintiffs' lawyers, to those on the municipal side and state side who will be tasked to defend the law and the counties and the city's actions. Unfortunately, Commander Sass from the St. Paul Police Department was not able to stay, but he would have testified to the importance that local police, such as St. Paul and others across the state, find in encouraging members of their communities, particularly from diverse and immigrant communities, to trust local law enforcement. At Immigrant Law Center, we represent crime victims. These are immigrants who've been victims of serious crimes, ranging from sex assault to domestic violence to coercion and human trafficking. Under federal immigration laws, they have a right to present their cases. Under the bill that's presented here, cities and counties would be encouraged instead to make decisions as to their legal status and prevent them their federally entitled right to present a case. The term sanctuary cities is currently the subject of multiple litigations across the United States. I won't reference all of them, but I encourage you to look at this very carefully because it is actively being litigated. Just yesterday in the Seventh Circuit out of Chicago, the circuit upheld a nationwide injunction against the administration for using the sword of funding to conscript state and local governments to enforce federal civil immigration law. Actions in LA, in Philadelphia, in San Francisco have reached similar conclusions, particularly the case in San Francisco, I point out for this committee, included in its concern the fact that there is no definition federally in state or city law as to what a sanctuary city is. I want to turn for a moment to concerns about the drafting of this portion of the bill itself that I think need further review before moving it forward. Earlier, staff to the committee, I believe, stated that revisions from 2 days ago on line 82.3 were created to comply with, and I didn't quite hear whether that was the INA or the IRS regarding undocumented alien. I would point out first that there is no term undocumented alien in the Immigration and Naturalization Act. So I'm not sure where the term comes from. It is defined by the IRS. However, the IRS definition is not the definition on this page. At line 82.5, 4 specific types of visas are called out. And it's unclear to me why the other 43 types of visa holders would not be included. Moving to the sanctuary city provisions, it also appears to me the construction is not consistent or clear. While the title suggests the target is sanctuary cities, on line 82.17, home rule charters, which I believe would include places like Hennepin County, are also included. Yet throughout the remainder of the penalty provision, it's only cities that are cited that could be penalized. So again, I'm not certain of the clarity or the intent. And finally, in the 5 provisions starting on 82.19, the first one, 82.19, an employee is prohibited from inquiring about the immigration status or a person's citizenship status under this bill. And I want to think about what that would look like. So under what circumstance would a city or a county employee be able to and not be able to ask my citizenship? What if they prefer to ask citizenship only of persons with brown skin or wearing a hijab or somebody that they perceive to be an immigrant or a non-citizen?
Mr. Keller, can you stick to the bill, please?
I believe this is in the bill. The other 4 provisions of this section, beginning with 2, 3, 4, and 5, again attempt to direct the city employee and the city itself as to who they should be able to conduct some sort of action at. And the only provision there that requires their conduct to be lawful is on 82.20. Sections 1, 3, 4, and 5 similarly don't require lawful conduct. Finally, in the provision beginning at line 83.29, I believe the intent here is that any taxpayer in one of these jurisdictions may challenge a city mayor's certification as to whether a city is or is not a sanctuary city. If you look at the ongoing litigation I've already referenced, and I've only referenced a piece of it, across the country, attorneys, both for municipalities and challenging municipalities, are trying to define exactly what a sanctuary city is. If you are to give a private right of lawsuit to any taxpayer, whether they want to challenge a city's statement that they are or are not a sanctuary city, I defer that you are, in fact, bringing that litigation to these cities and to these counties. This bill is not, or this amendment, this portion is not ready to be moved forward, and I encourage you to send it to its proper jurisdictions.
Thank you, Mr. Keller. Questions for Mr. Keller, members? Okay, thank you, sir. Our next, Ms. Nauman, and then Ms. Kelleher next, and then Mr. Cronquist after that. Ms. Nauman, welcome.
Thank you very much, Mr. Chair and members. My name is Patricia Nauman. I'm the Executive Director of Metro Cities. Thank you for the opportunity to comment this afternoon on the Property Tax Division Report. Metro Cities does have a number of concerns with provisions in the division report that would restrict or constrain local decision-making and local budget decisions. In Article 3, the provision that does offset local government aid for expenses associated with local actions and policies is something that Metro Cities opposes. The organization's policies do support an LGA formula that is based on need and capacity factors and supports a formula-based allocation of local government aid. The organization does oppose reductions that attempt to influence local policy decisions, as this does compromise the intent of the LGA program as a general purpose aid to local governments across the state. In Article 4, Metro Cities does oppose constraints on a local government's establishment or renewal of local or municipal franchise fees, which does interfere with local public processes for setting those fees. And in Article 4, Metro Cities would oppose the reverse referendum requirement for public officials leasing public buildings. Mr. Chair and members, I do appreciate your consideration today of these comments and would ask that you consider them as you prepare your final division report. I'd be happy to stand for any questions.
Thank you, Ms. Nauman. Questions for Ms. Nauman, members? Hearing none, thank you. Ms. Keller, then Mr. Cronquist, and then Ms. Doslin. Ms. Keller, welcome.
Thank you, Mr. Chairman and members. My name is Grace Kelleher, and I represent the Minnesota School Boards Association. And I'm here today to particularly talk about what's on page 86 and 87. They talk about changes to our referendum revenue. And let me just give you the present state of affairs. In 2017, we, through much compromise, came up and passed a law that said school districts could have elections on 5 days a year. They would be the first Tuesday in February, April, May, or August, as well as the November general election. We feel that is a good way to go, and you may need to give us more time and let us really evaluate whether 5 dates are good for the public than moving to one date itself. This goes on to say that on the notice and the ballot statement, we would include things like board-approved local optional revenue, board-approved referendum authority, and all those numbers placed on a ballot. I just want to suggest to you, if you were a voter going in to look and to vote, and you'd see those numbers across your ballot, would you understand what they meant? Now, some of you who spend a lot of time in education probably know that answer. But for a regular person going into the ballot, how would they understand the ballot? How would we go about sharing what those numbers are? And then there's always the one that goes in and looks like, that's plenty of money. Problem is, if you're going to have us look at how many dollars we ask our public for, you need to give them a picture of our budgets. And they include things like our cross-subsidy special education money. And by grouping these levies, something you've all talked about, Safe Schools levy is grouped into there. Now that number is going to go up because I feel you guys are going to give us more money in that area. But those would all be things that are under these nuts on the ballot and in the notice that I believe would cause significant confusion. Lastly, we just don't feel at this time this is needed. So, Mr. Chairman, we'd appreciate your consideration as you go forward, and I'd like an opportunity to thank your staff. They have been exceptional to work with.
Thank you, Ms. Kelleher, and I think everyone around this table agrees with that last statement. Questions for Ms. Kelleher? Okay, thank you, Ms. Keller. We have Mr. Cronquist, Ms. Doslin, and then Mr. Carlson. Mr. Cronquist, welcome.
Thank you, Mr. Chairman and members. My name is Scott Cronquist with the Association of Metropolitan School Districts. And I'll try to be brief because I really have the same concerns that Ms. Kelleher just identified. They are in Article 4 of the referendum article. As Ms. Kelleher noted, we really think that the additional language that would be required on the ballot there would really provide more, or lead to more confusion, actually, for voters rather than clarification. As you know, school districts are already required to send out a notice by mail to every taxpayer in the district that they have to receive that at least 15 days, but no more than 30 days before the election. It has to list the anticipated amount of the tax increase on all the different properties in that school district. And then, as you also know, our ballot question already has to say that passing this referendum will result in an increase in your property taxes. So we think school districts already face a pretty daunting challenge in passing referenda. And in reality, they're the only local units of government that rely on these voter-approved referendum for basic operating expenses. As Ms. Kelleher noted on the elections, we think that the compromise that was just passed last year, establishing 5 dates for elections, is a good compromise that we hope you would allow to be in place for a while before further evaluating it. And as a reminder, operating referendum elections actually already have to be held on general election day in November unless the district is in statutory operating debt. So I'll leave it there, Mr. Chairman. Thanks for the opportunity to testify.
Thank you, Mr. Cronquist. Questions for Mr. Cronquist? Thank you. We have Ms. Doslin, Mr. Carlson, and Mr. Hilgard. Ms. Doslin, welcome.
Thank you, Mr. Chair and members of the committee. My name is Valerie Dosland, and I'm here today representing the Minnesota Association of School Administrators and the Minnesota Association of School Business Officials. I'm glad I kept my testimony from last year, Mr. Chair. I didn't have to do a lot more work last night, so.
We aim for efficiency, Ms. Doslin.
I'm here to just express our concerns about the election provisions in the bill. You know, as Ms. Kelleher and Mr. Cronquist stated, we did have a significant change to election dates last year with the 5 uniform election dates. And I just want to talk briefly about why we have concerns. First of all, changing the election so that bond referendums can only be held in November of the general election year affects the timing of school district projects. The Minnesota construction seasons are short, and allowing for elections outside of November gives school districts more time to plan and design and construct new facilities. And sure, we could have elections in November, but especially if the district is doing a very significant remodel or rebuilding or doing a new school, because of the timing of the process that school districts have to use in order to plan and bid and get contracts and get approval, you could delay school construction projects. And I know there's a sense that, you know, general elections might have lower turnout, but they do draw more focused scrutiny. It's widely known that voter turnout is lower when elections are held outside of the general election date, and even lower when it's not a presidential election year. But that does not make school districts less accountable for the needs of the students or the fiscal responsibility and impacts of the taxpayers, or accountable for the need to communicate with the taxpayers about the need or the information for the election. Off-general elections can often draw more scrutiny because they are not getting kind of hidden by all of the other elections, based like the state representative races. Everyone pays attention to those, don't they? Or the presidential election or the governor's race. And it allows the school districts to provide a lot more context and direct conversation with voters without getting lost in the noise of other elections. Elections that aren't held in November do fail. I looked up the election information for bond elections for the last 2 years. More than half of the elections failed. So I think it's not a sense that, excuse me, I'm sorry, just because the district decides to hold the election off, it's not a guarantee it will pass. And I think that there's a sense that school districts might make that decision to hold the election then because they think that's the most likely time it will pass. That's not the case. Districts choose those dates based on the needs of the construction projects in their school districts. Thanks for your opportunity to testify, and I'll keep this for my testimony for future years.
Thank you, Ms. Doslin. Questions for Ms. Doslin? Okay, thank you. Then we have Mr. Carlson, Mr. Hilgart, and I think I heard Ms. Callison said Mr. Sass isn't here, but Mr. Carlson and Mr. Hilgart. Mr. Carlson.
Mr. Chair and members of the committee, my name is Gary Carlson. I'm with the League of Minnesota Cities. I want to thank you for the opportunity to testify today. Let me mention on Article 1, Section 14, this is the Representative Bennett bill. We don't have a specific policy on that particular issue, but I've heard from a growing number of cities around the state, smaller rural cities, that this is becoming a big issue, and we appreciate generally you adding some of that language that would allow some tax reductions for certain medical facilities. And I'll keep working with you, Mr. Chair, as we hear more from our cities in the future. But I think generally we've heard that concern, and I think this starts to address the issue of the location of those facilities. I'd like to respectfully oppose Article 3, Sections 3, 4, and 5, as I testified earlier this week. Those are the provisions dealing with the defense of immigrants and the sanctuary city provisions. We do oppose those. We do oppose adding additional penalties to the LGA formula, as Ms. Nauman indicated. We've increased the number of penalties off the LGA formula with, I think, the effect of trying to direct local government spending. We respectfully oppose those types of penalties in state statute. On Article 4, generally, we don't see the need to move the election dates to the first Tuesday after the first Monday in November. I do appreciate, Mr. Chair, you adding the language in Article 4, Section 2 for us that does address the issue of emergency debt issuance. That will help if we do run into a situation where debt needs to be issued quickly because of some sort of an emergency or disaster. So thank you for adding that if this does stay in the bill. And then on Article 4, Section 4, this is the Vogel franchise fee language. And we do oppose this. And I'd like to point out one issue that was raised to me by a member of the other body who was a former city official who said that basically this could create some budgetary problems for local units of government or for cities in particular because if we have to do a reverse referendum, especially if it's done after July 1st of the year, there's uncertainty as to whether any franchise fee revenue would come in under this provision. So I'd like to continue to work with you on the dates that this would apply. And then Article 4, Section 7, this is the lease purchase language from Representative Runbeck. We do oppose that. And I would like to point out one other issue is that between Article 4, Section 4, the Vogel franchise fees, you have one standard for a reverse referendum trigger. That's 5% of registered voters. And in Article 4, Section 7, the reverse referendum, it is 10% of the votes cast in the last general election. That's a more volatile number. If a general election includes a presidential election, you'll have a lot more voters than an off-year election. But it would be nice to standardize some of those voter thresholds triggering reverse referendums. So with that, Mr. Chair, I would stand for any questions.
Thank you, Mr. Carlson. Questions for Mr. Carlson? Thank you, Mr. Carlson. Mr. Hilgart, and then I believe Ms. Bergman and Ms. Nelson. Mr. Hilgart, welcome.
Mr. Chair, members of the committee, thank you very much. My name is Matt Hilgart, and I work for the Association of Minnesota Counties. We have 3 provisions in this bill that we'd like to thank you for, and then 3 that we do respectfully have concerns with. Firstly, AMC supports the MACO tax forfeiture language, which is in Article 1, Section 11. This language allows counties to get tax forfeiture properties back onto the tax rolls quickly and in private hands, and expands kind of the scope of people that may be purchasing these properties. We'd also like to thank Representative Whalen for her hard work and due diligence on Article 2, which is the property tax simplification components of this bill. The one thing I would note is that we don't have these figures yet, but we are looking at what the computer technology updating costs would be to get our software in accordance with the things that are in this statute. So thank you for that, Representative Whalen. Lastly, we appreciate the tax abatement language targeting local communities that have had to deal with a hardship or disaster. Our concerns to this bill, though, are related to provisions that would limit or punish local governments for making decisions made by locally elected officials. And I guess I would start with the language regarding undocumented alien defense. I won't go into lengths about this since I already did in a previous committee earlier this week, but we would ask that you keep local government aid, local government aid. On the referendum language on lease purchase bonds in Article 4, Section 7, I think what we would add in addition to what Mr. Carlson already stated was that sometimes the things that counties invest in or must invest in aren't the most popular things. And when I say that, I think of jails. And there are several counties in the state who have had to make investments in their jail systems upon order of the state. And we take those the financing of those projects very seriously. We hold public meetings, but I can tell you this, that not many people or residents want to be spending property tax dollars on jail. So I would just give that as an example of things that you may want to keep in mind. Lastly, I want to touch on the language requiring Hennepin County to give certain communities a percentage of their local option sales tax revenue. Aside from being an elected body, which you've heard before, the projects using these funds go through a very thorough and collaborative process, and they are projects of regional significance. And one thing that I would mention and just warn is that if this committee decides to set the precedent or this gets signed into law, of communities they may be coming to you in future years asking for similar legislation. And I would just put that out there. So thank you very much, Mr. Chair, for allowing me to put those on the record.
Thank you, Mr. Hilgart. Questions for Mr. Hilgart? Thank you, sir. Next, Ms. Bergman, then Ms. Nelson, and then I think Mr. Carlson. Ms. Bergman, welcome.
Thank you. Good afternoon, Mr. Chair and members of the Property Tax Division. My name is Sasha Bergman, and I'm here representing the City of Minneapolis. I appreciate your time today and the opportunity to testify on the Delete All Amendment adopted in House File 465, the Property Tax Division report. First, Mr. Chair, I want to thank you and members of the committee for including the tax increment financing provisions from House File 3300 authored by Representative Fu Lee. This is for the Upper Harbor Terminal in North Minneapolis. The provisions on page 109 of the Delete All Amendment are a critical tool for us to make some of the needed public infrastructure improvements on the site for whatever development will follow. I do want to note for the record that we respectfully oppose the repealer contained in Article 3, Section 7 related to our library debt service aid, which has been a partnership between the state and the city to complete debt service payments on the Hennepin County Central Library in downtown Minneapolis. Mr. Chair, I also wanted to note that the city supports the current local government aid formula as reformed in 2013, and we support distributing aid based on the factors of the formula. And as such, we are opposed to the provisions in Article 3, Sections 4 and 5 of the Delete All Amendment, which propose allocating local government aid based on other factors, such as by withholding aid for cities which are defined by the language as a sanctuary city. And with that, I'll conclude my remarks for the day.
Thank you. Questions for Ms. Bergman? Thank you, Ms. Bergman. Ms. Nelson, welcome.
Thank you, Mr. Chair, members of the committee. My name is Teresa Nelson, and I am legal director for the ACLU of Minnesota. I'm here to talk to you today about our concerns about Article 3, Section 5 of the bill. We oppose this provision because we believe that it will coerce local law enforcement in local officials into complying with immigration and customs enforcement detainer requests, which will in turn lead to violations of the Fourth Amendment and Article 1, Section 10 of the Minnesota Constitution. Detainer requests are not warrants. They're only based on suspected violations of civil immigration law. Hundreds of detainers over the past several years have been issued for U.S. citizens. I think we can all agree that U.S. citizens are not deportable under our immigration laws. Detainers purport to give local law enforcement, that includes both local police and county jails, the authority to hold a person for up to 48 hours beyond the time they must be released under state law. There is no such authority. Detaining people based on suspected civil immigration violations without probable cause violates the Fourth Amendment and Article 1, Section 10 of our state constitution. Federal court decisions are piling up on this issue and finding that the practice is unconstitutional. Recently, a Colorado state court also found that it violates their state constitution. In 2016, in a case filed by the ACLU against Nobles County, the U.S. District Court here in Minnesota also rejected the county's argument that an ICE detainer was sufficient to protect the sheriff from liability for holding someone beyond their release date. Now, make no mistake, if counties and cities are sued in Minnesota for honoring ICE holds and violating the Fourth Amendment, ICE and the federal government are not going to be here to defend those cities and counties. The bottom line is that state and local law enforcement should not be in the business of immigration enforcement. That responsibility is assigned to the federal government under Article 1, Section 8 of our U.S. Constitution. Our concern should be to strengthen community trust in local law enforcement and to ensure public safety. This measure does neither of those things. Victims and witnesses of crimes shouldn't have to fear calling the police, but that's what happens when the community fears that contact with law enforcement will directly lead to immigration proceedings. And so because we think that this is a waste of scarce taxpayer resources, will lead to constitutional violations, and it contradicts our sense of fairness, we respectfully urge you to remove this provision from the bill. Thank you.
Thank you, Ms. Nelson. Questions for Ms. Nelson? Thank you, Ms. Nelson. Mr. Carlson and Mr. Cummings and anybody else who wants to come up and speak. Mr. Carlson, welcome.
Thank you, Mr. Chairman, members. I'm Keith Carlson, Executive Director of the Minnesota Intercounty Association that consists of 4 suburban counties and 10 Greater Minnesota Regional Center counties. I do want to start out by thanking the Chair, Representative Whalen, and your staff for the important work that you did on Article 2. With the reforms on the residential classifications and the various due dates. I do, however, want to reiterate the comments of Mr. Hilgard that we do need assistance with the cost of reprogramming our computers to deal with this. In the past, on some of the occasions when large property tax law changes have been made, the state has provided assistance for those reprogramming costs, and we hope that you do so again. Also want to compliment Representative Erickson and her House File 1268 and its inclusion in this bill for providing relief to the Lake Mille area businesses affected by the walleye fishing ban. I do want to again reiterate the counties, cities' concerns with the provision in Article 4, Section 7 of House File 112, providing the reverse referendums on lease purchase agreements. This in conjunction with the uniform election or referendum dates and also possibly the changes that you may adopt in the A8 Amendment would be particularly onerous for smaller Greater Minnesota counties. The burden that would be placed on their homeowners under the combination of all 3 of these provisions could be substantial for homeowners, and do want to warn you that this puts those counties in an untenable position of, as Mr. Hilgard mentioned, having to comply with a state order to rebuild or rehabilitate their jail, or to meet our obligations to the state to provide adequate facilities in our courthouses for the state's district's courts. Also, again, wanted to say that we also oppose House File 3482, diverting a portion of Hennepin County's local option sales tax to the cities. This is clearly unprecedented in taking a locally authorized tax that was represented to the taxpayers of Hennepin County per the requirements of the law for certain purposes and requiring it by actions of this legislature to be spent for other purposes. Finally, want to mention regarding the CPA penalty relating to defense of illegal aliens. I had brought to the attention of the chair and your staff a need for an amendment for those instances where county attorneys may have to intervene in those hearings to keep a defendant, a material witness, or a victim in town for criminal proceedings or investigations leading to those proceedings. The particular issue that was brought to my attention, there was the triple murder in Washington County where several illegal or undocumented aliens were material witnesses to that crime. The county attorney's office did have to intervene with INS to stop deportation hearings so that those witnesses could be kept in town to witness those trials and result in the successful conclusion of that case. I please ask you to add that language so that exception does not result in a CPA penalty. That I'll conclude. Be happy to answer any questions.
Thank you, Mr. Carlson. Questions for Mr. Carlson? Mr. Carlson, did we have the amendment in the bill?
No, you do not have the specific language in the bill that would.
We do not. Okay, thank you. But we may get it in there later. Thank you. Mr. Peterson, welcome.
Thank you, Mr. Chair. Members, my name is Bradley Peterson, here today on behalf of the Coalition of Greater Minnesota Cities. We share many of the same concerns that Mr. Carlson and Ms. Naumann articulated about this bill, but I wanted to focus my comments specifically on the LGA penalty as it related to the issue of defense of undocumented aliens and the sanctuary city issue. Since the early days of the program, the local government aid program has really focused on evaluating a city's needs and tax base. And that has been the hallmark, the underpinnings, the pillars of that program, and is something that our organization has supported throughout its history. And so we don't believe that the local government aid formula should be used as a tool to encourage or discourage policy decisions by local elected officials, and that the formula should run as the formula. The other thing that I want to bring to your attention, and one of the things that has not been mentioned, is it treats LGA receiving cities and non-LGA receiving cities differently. Non-LGA receiving cities do get state money for other things, but are not subject to any penalty if they run afoul of the policy issues that you seem to be looking to address here. With that, Mr. Chair, I'll conclude. Thank you.
Thank you. Questions for Mr. Peterson? Thank you, Mr. Peterson. Welcome. Please introduce yourself for the record.
Hello, my name is Angelica Perez, and I'm the Public Policy Program Manager for the Minnesota Coalition for Battered Women. We are an anti-domestic violence coalition that represents Minnesota's 90 domestic violence programs. I'm here today to testify against Article 3, subsections 4 and 5. Every year, the Minnesota Coalition for Battered Women publishes the Femicide Report, which documents victims of domestic violence homicides. In 2017, we identified that 3 of the 24 victims were from immigrant communities. Immigrant victims or survivors of domestic violence face additional barriers to safety due to their citizenship status or lack of language access. Perpetrators commonly use the immigration system to further abuse them by threatening deportation, not giving the victim access to their documentation, or not completing their partner's immigration application. It is because of these problems we oppose Article 3, subsection 4, which removes funding from local governments to provide their residents the ability to obtain fair representation. The ability to obtain counsel is a matter of due process and safety for immigrants, especially for immigrant survivors of domestic violence. Further, we oppose Article 3, subsection 5, which would punish cities that allow police to focus on community priorities rather than target people based on their immigration status. This cuts local government aid that supports public services, including domestic violence and housing resources. When members of the community can report sexual assault, domestic violence, and other violent crimes, and seek protection without fear of being deported or separated from their families, safety increases for everybody. Thank you.
Thank you, Ms. Perez, right?
Yes.
Okay, questions for Ms. Perez? Thank you. Mr. May.
Mr. Chair, members of the committee, Tom May on behalf of the Minnesota Association of Assessing Officers. First of all, I'd like to thank Representative Whalen for her work on the tax reform and especially the residential simplification that's in the bill. We only wish that the seasonal rec residential could have been included in that, but it's not. The other thing I wanted to just reiterate again, and I've said it many times before, is we're concerned about the growing complexity of the ag homestead classification. Thank you.
Thank you for your brevity, Mr. May. Questions for Mr. May? Okay, Mr. Cummings, welcome.
Good morning, Mr. Chair and members of the committee. For the record, my name is Paul Cummings, and I'm the Tax Policy Manager at the Minnesota Department of Revenue. wanted to thank you for the opportunity to testify today.
It is
Afternoon.
Oh,
It is afternoon, Mr.
boy.
Cummings.
Time
past-
flies when you're having fun, Mr. Chair.
Thank you, Mr. Cummings. Glad you're entertained.
We wanted to thank you for the due date change for the Senior Citizens Property Tax Deferral Program. That is a good provision in this bill. Wanted to provide some comments on some of the other provisions in this bill. Mr. Chair, there seems to be a focus on preemption within this bill. Local government aid is tied to certain behaviors of local units of government. LGA is there to ensure that we have livable communities. So tying various social agenda items to the issuance of aid ties the hands of locally elected officials and says to some areas of the state, says that some areas of the state should have access to livable communities more than others. Mr. Chair, in terms of the fractional homestead issue, I appreciated the discussion that we had this morning, and I think we still have some work to do in that area. We're still reviewing the change in tax base for the state general levy. We think initially that's concerning, but we're interested in learning more. There seems to be lots of changes to Ag Homestead, making it more complicated, but we would like to work with Representative Anderson to learn more and to ensure that it stays within the longstanding policies concerning Ag Homestead. But I think we understand some of the things that are trying to be done there. There's a provision on Zipperell, Mr. Chair. The proposal prohibits any appropriation or other state money from being used by any governmental unit on really even studying the feasibility of a rail project between Rochester and the metro area. So this is another area where the legislature is working to preempt the decisions of locally elected officials. We would have some concerns about that. As it relates to the Hennepin County sales tax, this is another example of the legislature trying to make decisions from St. Paul for local units of government and take decision-making power away from locally elected officials and those the closest to the people. I think this just shows that maybe we could work towards a long-term solution for transportation financing. We don't think it's an example of a need for additional preemptive actions. The governor does oppose this proposal. There is an item in here relating to the Department of Revenue providing a taxpayer notice of lost benefits or change in due dates. Really puts a new burden on the Department of Revenue to develop and implement a plan to notify all these property tax owners in the state of Minnesota. It is outside of our normal capacity, but you know, we do have a commitment to ensure that the tax system works well for Minnesotans. And so we look forward to working with this committee to try and figure out what is the best way to provide sort of communication with taxpayers across the state so that we can have a tax system that continues to be credible and works well. We can provide examples of how we do that when there are sales tax rate changes or base changes. Mr. Chair, I wanted to talk a little bit about the Department of Revenue Service and Recovery Fund. This fund is for the local option sales tax account. This impacts the department's ability to change any staffing levels to really support local units of government. Last year, the number of local option sales taxes increased dramatically as a result of changes in the 2017 omnibus bill. We added 17 last year alone as a result of those changes. And then there is an ever number of increasing local option sales taxes related to transportation funding. And last year there was even one relating to the Garrison-Cathio Water Sewer District. The number of local option sales taxes are increasing, and as they do once again as a result of this bill, local governments are expecting quicker turnaround times in activating those taxes. Given that it makes sense for the legislature, it really doesn't make sense what message that you're sending to the Department of Revenue by making us less able to accommodate local units of governments by removing this funding. I think it was earlier this month or last month, we did send out to some staff members and I think to some representatives as well, sort of a beta version of a new sales tax calculator. so people could try and figure out the lines in terms of trying to figure out how taxes are done. We're really proud of that work, and we want to continue to provide more tools so people can navigate our extremely complicated local system of local option sales taxes. There's a large change in this bill related to the public financing of elections. So we're concerned about changes that would move towards the financing of elections towards the rich and well-connected rather than having elections publicly financed. The repeal of Minneapolis library aid is troubling. This is a commitment the state has made, and we should keep our commitment. The governor has shared his opposition to this in the past. We're still reviewing other parts of the bill. The reverse referendum provisions and other elections provisions have been troubling in the past, and we're still looking at them. We want to spend a bit more time with the proposal on changing class rates to figure out the impact and what that does, Mr. Chair. There are new special carve-outs in this bill that we want to further examine. The senior citizens property tax deferral changes, we're still planning on meeting with one of the chief advocates. We've met many times internally, even after the bill hearing, to try and understand that, and we will be meeting with the advocate to ensure that the changes actually deals with her needs. There's also changes to Homestead related to small resorts, and there are other changes that we would continue to want to work on. But with that, Mr. Chair, I think we want to work in partnership with you as this bill moves forward. We are certainly committed to a tax bill this year. It's absolutely essential so that taxpayers can have clarity as it relates to tax filing, especially related to the Tax Cuts and Jobs Act and our reaction. And so we appreciate the opportunity to testify.
Thank you, Mr. Cummings. Questions for Mr. Cummings? Thank you, Mr. Cummings. Anyone else would like to testify on the bill? Okay, I think that concludes testimony. Thank everybody who came up to speak on the bill. Members, I think we're moving into the amendment phase. The chair does not plan to take testimony on the amendments, so with that, who would like to bring the First Amendment? Oh, I guess I have one. I don't know if Mr. Carlson's still here, but we've got the amendment. There was an oversight that we left out the piece on the sanctuary city piece, or the legal defense fund for the undocumented aliens. So members, I move the A22 amendment, and we'll wait to vote until it gets around. But this is exactly, I think, the same language that I had in front of committee when this bill was heard 2 days ago, and Mr. Carlson, I think, helped us in drafting it, and this was a concern that he raised in testimony earlier. So thank you, Mr. Carlson, for catching the fact that it wasn't in there, and we have it in front of us now. So questions, the amendment is moved. Any questions on the amendment? Hearing none, all in favor of adopting the A22 amendment signify by saying aye. Aye. Opposed, no. Motion passes. The amendment is adopted. Okay. Representative Rarick has an amendment.
Thank you, Mr. Chair. I'd like to move the A19 amendment.
Okay. Is that that's in our packet, I believe? Or no, it's...
Came late, so it's probably...
It was passed around. Does everyone have the A19 amendment?
Right here, Mr. Chairman.
Okay, it's coming around, members. Representative Rarick moves the A19 amendment. Representative Rarick, do you want to describe the amendment as it's going to members?
Yes, Mr. Chair, the A19 is Representative Sundin's bill that we heard earlier in regards to Cloquet. They had a bond referendum that went out, was approved by the taxpayers. If you remember sections, they had 3 areas it was going to be divided amongst. Section number 2, they were not going to be able to use all of the funds in that area. There was some concerns about moving it into Area 1. So working with the city, it has been redrafted to allow the money not spent in Area 2 to be used in Area 3. And then there's a provision to change it so they could use it for roads and bridges under Area 3. So that would allow the voters already approved the money. It's just allowing them to use it in a different area than was originally specified by the legislature.
Okay, does everyone have the amendment? Did it get around? Okay, questions for the author on the amendment? Okay, are we ready to vote? Seeing none, all in favor of adopting the A19 amendment as presented, signify by saying aye.
Aye.
Opposed, no. Motion passes. The A19 is adopted. Next amendment. Representative Lean.
Thank you, Mr. Chair. I do have an amendment. It is the A4 amendment. And I do have to make just a quick technical correction if you'll allow an oral amendment. Line 1.1, I have the first engrossment, so just to strike that language. And in place of it, let's see. We would have to add the delete.
We're still digging for the amendment,
Okay.
Representative Lean. It's A4, and you did move the amendment, right?
Mr. Chair, I will move the A4 amendment.
Okay, Representative Lean moves the adoption of the A4 amendment. Go ahead, Representative Lean.
And Mr. Chair, as I was saying, just get everyone on the same page, it would be line 1.1 to strike the language, the first engrossment, and insert the delete everything amendment, parentheses, A18-0818, parentheses.
Okay, could Mr. Clayman or Ms. Dalton repeat that amendment and get us on page here? Ms. Dalton.
Mr. Chair, basically, this is just clarifying that what he is amending is the A18-0818 amendment.
Okay, so we're good to go the way it is, Ms. Dalton? Are you okay with that, Representative Lean?
Yes, Mr. Chair, yes.
Okay. Representative Lean, so I wasn't listening very well to Ms. Dalton as I was interrupted, but Ms. Dalton, did you say that we don't need to amend this amendment? Ms. Dalton?
Okay.
Or just incorporate it?
Okay.
We think staff will get this right without
Okay,
without us doing
okay, thank you, Mr. Chair.
without
Just
us
make
doing
sure
it.
everyone's on the same page.
Okay.
But Mr. Chair, Bay and members, basically this amendment brings some technical clarifying language into the existing border city statute. If you read the existing statute the way it is, it's kind of complicated, it's redundant, and at the same time contradictory. So this is purely cleanup language, basically to allow the businesses that have been receiving the border city benefits, as long as the program has been in existence, to continue receiving those benefits.
Thank you. Discussion on the A4 amendment. Okay, hearing none, all in favor of adopting the A4 amendment signify by saying aye.
Aye.
Opposed, no. Motion passes. A4 is adopted. Next amendment. Who is it? Representative Lunan?
Thank you, Mr. Chairman. I'd like to move the A12 amendment.
Okay. The A12 was distributed, I think, in your packets, members.
Mr. Chairman.
Representative Lunan moves the A12 amendment.
First of all, I have to acknowledge that disappointed that we couldn't take testimony. I had some testifiers come down here, and if military people still cuss like they used to, there's some guys in their car right now cussing pretty good because they didn't get to present on this. The A12 amendment does three things. It allows a one-time transfer to a home you're moving to. The veteran, the disabled veteran, or their spouse, as long as the house you're moving to is of equal or lesser value, you still get the exemption, the veteran benefit. The second thing it does is we're maintaining in there an 8-year window of time, a window of opportunity to take advantage of that tax break. And also the problem with it is, and I'm going to end up pulling the amendment, is that this amendment, even though it's tax neutral, does create an extra burden we still need to work out with the counties. When you move out of your house, right now they want to make sure that the person who's not a veteran, a qualified person, isn't receiving that benefit. And the house you move to, that property tax has to be adjusted right now. And the way this amendment is written, we would ask that happen instantaneously. But so we've got some things to work out with the county, so I would like to withdraw the amendment.
Thank you. Representative Lunan withdraws the A12 amendment. Representative Markwart.
Thank you very much, Mr. Chair. And I actually have two amendments. This first one is the A21 amendment, and it needs to be passed around.
Okay, can staff help distribute the A21? Representative Markwart moves the A21 amendment.
So, Mr. Chair, what this does is just improves this. This was a bill we heard, I think it was Representative Johnson, that dealt with a parcel of land where there had to be a holding pond built to control water that was going onto an expressway, but because he had to use that, it went under the 10 acres, and so then it wasn't considered agricultural classification. And this keeps everything in place except add basically the work has to be done in accordance with USDA Field Office Technical Guide Conservation Practice Standards. So just make sure that the work is done properly. So that's the amendment, and I ask for committee support.
Thank you, Representative Markwart. Questions for the author or discussion on the A21 amendment? Okay, Representative Hertaus?
Thank you, Mr. Chair, and thanks, Representative Markwart, for this. I just wanted to let you know, too, that we discussed the possibility of trying to make my agricultural definition modification to include Representative Carlson's bill regarding that specific instance, but we just decided in the end to leave it as it is, so thanks for clearing this up.
Thank you.
Thank you. Other questions or comments? Hearing none, all in favor of adopting the A21 amendment signify by saying aye. Aye. Opposed, no. Motion passes. Motion passes. The amendment's adopted. Did I say the wrong author?
No.
Okay. It's Representative Markwart's amendment. Okay, Representative Markwart?
So thank you very much, Mr. Chair. I'd like to offer the A8 amendment. I think members have that in their packets already, Mr. Chair.
Okay, Representative Markwart moves adoption of the A8 amendment. Representative Markwart.
Thank you very much, Mr. Chair. And members of committee, back in February, we had an informational hearing on this bill. This bill's authored by Representative Drazkowski, and it's a bill that he and I have worked on for a couple years. And members, we have a very unfair situation in our property tax code. And it deals with debt service on school building bonds. And years ago, when we were a state, initially you had about 60% of the population that lived on farms. And then in the 1900s, you had about 40%. And today, you have about 2% that live on farms. And yet, in the rural areas, while you have 2% that would be able to vote on a school building bond that has agricultural classification, they comprise, that property class on the average comprises 34% on average. So you've got 2% of the folks picking up 34% of the tab, and that's your farmers. And in many cases, I said that's an average. And in many cases, I know in my district, Dilworth, Glen, and Felton, it's 64%. Barnesville is 74%. You get to Rothsay and Campbell Tinta, it's 80, 90% with very little population out there. And so while state demographics have changed, the debt service bonding election laws haven't, quite frankly. And so this is very unfair, and I do think it threatens the ability of the state to live up to Article 13 of our Constitution, which is a uniform system of public education. And the reason I say that is because if you look at the last 3 years of 2015, 16, and 17, and look at the school building bond referendum results, in rural Minnesota, the success rate is 45%, and in the metro, it's 75%. 45% success rate to 75% success rate in the metro. And I think a big part of that is this very untenable, unfair position we've put the agricultural landowners or farmers into. Now, I do want to say, when I get to this point, a big thank you to Governor Dayton and Representative Drazkowski and House and Senate leadership for the 40% credit from last year. That went a long ways in helping to correct this. But I've got some information right here from Goodhue School District that they're looking at doing about a 30.2%, a $30.2 million project. And even with the 40% in Goodhue, the ag land will pick up 40% of the tab, and the homeowners and the residential about 25%. So that still is a pretty big disparity in there. So the current system really penalizes those agricultural districts that have a large percent of farmland. They are paying an untenable amount. And not only is it unfair to farmers, but it's unfair to students, because no matter where you live in this state, you should have the same opportunity to a top-notch, world-class educational facility as anywhere else. And right now, quite frankly, because of the way it's set up, with this huge ag land and the unfairness, that rural school districts are seeing just a little over half the rate of success of the metro. I think that's increasing disparity. So if I might, Mr. Chair, I think the best way to probably explain the bill, where there's a couple handouts. So one of the first handouts is this one right here, where it says on the top, new classifications of tax base under House File 2495. It's a landscape and should have my name on it up in the upper right. And this is information that is adopted from House research, something that was put together earlier when we had the informational hearing. But what we think, what we can do with this amendment is make a system, basically, right now when you go to vote, either operating referendum or debt service, you've got two different sets of law and two different sets of tax base. And so we think this would be simpler, more transparent. It restructures the tax base. And the key to remember is that it begins after June 30th, 2021. So this doesn't happen right away. There's some time before that would happen. So let's just take a look, if you will, at the chart. And there's 6 different classifications of property. And in the first column is the current referendum market value. And this would be the current for operating referendums. And operating referendums is when school boards go to the voters. It's usually an X amount of dollars per pupil unit to deal with just general operating systems in the school. And as you can see right now, agricultural land and seasonal rec is not taxed on that. And everyone else is based on their market value. So it's basically 100%, commercial, residential. The current debt levy in the next column is off of net tax capacity, where different classifications of property are assessed differently. And a debt levy is, of course, when a school district goes for long-term buildings, to build a new building, and usually it's a 20-year bond at whatever rate, tax interest rate and so forth. So there's where we sat before, where Ag Homestead was at 50%, or it was different with NTC, but this is how it converted. Agricultural non-homestead 100%, and then the commercial, depending on the amount, 150 to 200, and then residential and seasonal rec at 100%. This amendment, or House File 2495, would be the last and final column, and this takes place after July 1st of 2021, is that ag homestead and non-homestead land, it would not be included. Seasonal rec now would have 25%, and residential would remain at 100, and then you've got commercial over 150,000 at 125. So there are shifts depending on what you're doing here. And so what you're going to see when we're going to look at the runs here in just a second is that on your operating referendums, so the minute it hit July 1st of 2021, all of your operating referendums, if you look at the first column compared to the third column, you can see everything's pretty much the same except commercial industrial is going to see a little higher rate there than under the new versus the current. And so what you're going to have there is a bit of a shift from homeowners to businesses. And so the minute this would become law, if it did, homeowners would see a cut in almost all cases on their operating referendum levies. There would be a tax cut. Now, remember, this is without adding any equalization. The one thing this amendment does is right now there's only about $20 million of equalization out of the 900 and whatever it is, $80 million of bonds out there. This over time would increase that from $20 million to $95 million. So this equalization, any of the shifts that you see just looking at this chart is going to be mitigated by this increase in equalization. You're going to see some of this in just a second. And I'll also note that most of the $75 million of increased equalization is coming out of existing agricultural programs. This is a revenue neutral proposal. And so where it's going to come from is as ag land goes into this new formula, you wouldn't need any breaks on the debt service. So the bill that was passed last year, the 40% ag credit, would gradually phase out as the new ones come in. And that's almost $40 million right there that would go back into the equalization. Something else, there's an agricultural agricultural homestead market value credit that also every 10 years would gradually be phased out because again, if it went to this system, the benefit to the ag land would overshadow that many times over. And so that money then would also be put back into the equalization. So it's all contained there. So it's revenue neutral. Now, what you're going to see here is that there's about 65 school districts around the state that have a small enrollment under 500, but an ag percent of their tax base of 50% or more. And this amendment would set up a separate funding source for them. It'd be called the Small Schools and Cooperative Facilities Grant. It's about 64, 65 school districts. The reason that is set up is because in some of these cases, if you are taking ag land off of the debt service, that might be 70, 80, 9% on to the homeowners that might be 100 or 200 people, 300 people. It would be so cost prohibitive that they simply would not be able to pass a school bond. And so this allows them to go to the state in this situation and ask for funding. And this amendment would set up $2 million beginning in 2020 to be placed into this fund to build up over time. So you'd be able to take care of some of those districts, Mr. Chair, that just would be cost prohibitive. And the last thing you'd want to do with this amendment is to force districts into something they couldn't do just because of the money and so forth. So now if we could play a little game called Pick Your District. So if you could take out members, you should have this in your packets. right here. And so here's how it's organized. On page 7, towards the bottom is where the metro districts begin. And on page 1 are the rural districts, and they're from greater than 2,000, and they work their ways down. And if you will notice under the area where it says districts under 1,000 students, there's an asterisk by some of those districts, and those are those 64, 65 districts, I counted kind of quickly, that would qualify in that small school grant program, that are either, they're under 500 enrollment and 50% or more higher. So let's just look at the columns here, because it's important that you understand this as we kind of go through. So you've got your school district there, and then you've got an amount of a bonded debt election. If you're basically 1,000 or less in the rural, House Research has set up a $20 million bond. But as you're a larger district, and like Minneapolis, St. Paul, House Research has matched this up so that it is kind of in proportion to students and so forth. So you notice Minneapolis, St. Paul, you're looking, or in Anoka, Hennepin, the model is a $250 million bonded debt election, which tries to put things more in perspective of what the dollar amounts would mean. And so then you have the annual debt service required each year over 20 years. And I'm looking to Mr. Hines, so if I'm saying something incorrectly, just raise your hand or something here. Staff has done a wonderful work working with Representative Drazkowski and I on this, just super. So then you have the annual debt service required. And then under the current equalization, you would get certain state aid under equalization. So that state aid current law is what the district would receive now. And in that next column where it says state aid under House File 2495 is what it would be with the increase when it's phased in over time on the that extra $75 million of equalization. And so that's what you're going to see on this simulation is with that extra state aid. So let's take a look now and go to what would be the impact on a homestead. And the first column is the change to existing operating referendum. And in rural Minnesota, the simulation is $125,000 home, and in the metro, it's $225,000. And that would be the cost. You will notice, as I had mentioned earlier, the change to the existing operating referendum is going to be a reduction or zero. There's a couple that actually have like a $1 or $2 increase, and we're kind of trying to figure that one out yet. But for the most part, that will be immediate property tax cut for the referendum, operating referendum, for almost all districts, or at least they'll stay the same. And that is because it's shifting from the homeowners slightly to businesses. Now, that doesn't mean that taxes will go up in the businesses in that situation, because the equalization aid comes in and, again, mitigates shifts. So you have to look at the individual district. All right. So the bigger changes will occur later on here. So you've got then current law, and then you've got what would be now debt service in House File 2495. And so under the homestead tax impact, the fourth column, the last one, is the net tally on plus or minus in your district from current law to what would be the new law on the annual payment on the debt. And so that is homeowners. The next column is farm tax impact. Of course, you're going to see reductions there because there's a shift there, especially on the debt service. And there you have a $1.8 million farm. That is including the house, garage, and 1 acre. So that'd probably be maybe a 400-acre farm. And so you will notice that the third column there where it says House File 2495, the amount is going to match what your homeowner's amount is because it's the house, garage, and 1 acre. So that third column under homeowners is going to match the third column under the farm tax impact, because that's going to be the only tax that would be still levied on that area.
And Representative Markwart, I think that's except when we're in a metro district,
Yes, I don't think you have that one in the.
because that's based on a $225,000 instead.
Thank you,
of
Mr. Chair. That's exactly right. That's exactly right. And so then you move to the business tax impact. And there you can see, and this is where there's some give and take, is you would see on the operating, because there is a shift towards businesses, there, that first column would be an increase on the operating referendum. But the final column then would be the difference on a debt service. And there you see it would mainly be reductions. And then you can go to the cabin tax, the seasonal rec is kind of the same way on that one. So are there shifts, pluses and minuses? Yes. And as you look through there, on most of them, it stays within double digits. And quite frankly, you can say, all right, the system is fair and we don't need to make any changes. Or you could say, this system isn't fair. We've got to make some changes. And anytime you make changes, especially when you're using and keeping things revenue neutral, there's going to be some shifting. But I would strongly argue that this is much fairer, not only to more closely matching who votes for something and who pays for it, matches that more, but I say it's more fair to students around this state who I think there is a real disparity occurring here because of our current system in the level of services that, in fact, students are going to have. I know there's no testifiers, Mr. Chair, but I know there's a number of agricultural groups who are here in support of the amendment. And so I will leave it at that, but I think, and I want to thank you, Mr. Chair, Representative Drazkowski, because this has been your initiative. And it's been fun to work with you on this and staff also. But, is anything perfect? And I think maybe it could still be tweaked. As I look at it each and every time, you look at certain things. But I think it addresses a lot of the things and would really solve this untenable, unfair position. We've put a certain classification of property and a certain vital part of our economy, our farmers, into, and at the same time hurting our students in a lot of rural Minnesota areas. So, Mr. Chair and members, thank you for giving me some time to go over this.
Thank you, Representative Markwart. Mr. Hines, could you talk through I don't know if Representative Markwart went through the equalization numbers and how we get to 95? He went through them, but we didn't bring the sheet out.
I did not.
Representative Markwart, go ahead, Representative Markwart. I'll let you bring that
Yes,
sheet
I got to
up.
find that. That also should be in your packet, I believe.
I can
And
talk through
You
it.
have,
Okay.
Mr. Chair, go ahead.
Okay, I'll talk through it. So members, it's from House Research. It's a memo dated April 19th, 2018. And really, the nuts and bolts of it are on the back of that sheet in a table. And so, as Representative Markwart mentioned, currently for construction levies, the equalization amount that the state is using to equalize districts is about $20 million. And between 2022, when the bill would actually happen, when the tax base would change, and that of course is by design to give school districts the ability to anticipate and plan and decide what makes most sense for them to have the time that they need, so it's not just foisted on them immediately. But between, I lost my train of thought, so it's 20 million now, and these items on the sheet here in the table outline, I know where I was. So between 2022 and about 2041 or 2042 is when it goes up to $95 million of equalization. So the question is, how much equalization will there be on any year between 2022 and 2041 or 2042? And Mr. Hines can't tell us what that is, Mr. Strom can't, and I don't think nobody will know for sure, but we know, according to the way the bill is put together, and of course, future legislatures are going to make all kinds of changes as they do each year between now and 2041 or 2042. But if there weren't any changes, it would go from $20 million of equalization to $95 million of equalization for school construction projects. And the way that happens, members, as Representative Marquardt pointed out on this table here, we're at 20 million now, and we add 75 million in that. How many years is it between now and 2040? 25 years or whatever it is between now and then. And the way that additional $75 million is arrived at is, first of all, as Representative Marquardt pointed out, that school building bond credit, the money coming from the state that we passed last year, that $40 million, those rural school districts that are using that credit in 2022 for referendums that have already been passed and are already using the credit will continue to receive that credit and use it until those bonds expire and are paid off. And when they expire and they're paid off, then as Chair Marquardt pointed out, when that money becomes, when they're paid off, then that money is liberated from there and goes into the pool of debt equity aid or of equalization aid, if you want to call it, and adds to the pot. And that amount is between now and 2041 will be $36 million. It's actually less than 40, and it might go up a little bit next year depending what that is. But that's about $36 million. Then the $19 million, since we changed in the bill, and Representative Marquardt does in the amendment, the tax base, the referendum market value tax base, which the operating levies are now based on the referendum market value, we changed that, and that actually gets more tax base under this proposal. So it will draw less equalization aid from the state for the operating levies. That less equalization aid will then be available for construction levies, and that amount is about $19 million. And then the third one is the ag market value credit, and Representative Marquardt has in the amendment, we have it in the bill, as he mentioned, stepping about every 5 years, a reduction in the ag market value credit, and then making that money available for equalization aid into the equalization aid pot, adding up between now and 2041 to 75 million additional dollars available for school construction equalization aid above the 20 million that we have today. Mr. Hines, did Team Marquardt and Drazkowski miss anything? Very good. Okay. Any discussion? Representative Erickson.
Thank you, Mr. Chair. And I would just like to direct my question to Representative Marquardt, if that's okay. Representative Marquardt, we did not hear this bill in Education Finance because Representative Bloom had grave concerns about its effect. So I'm wondering, because you have been a finance chair as well, and I really admire the work that you and Representative Drazkowski have done on this, but what is the downside other than the shifts that you mentioned in some instances to commercial?
Representative Marquardt.
Thank you, Mr. Chair. I think overall there's probably an upside to commercial. If you kind of look at the results, and of course it's going to depend. If your district only has an operating referendum, they're going to see an increase. But if they have both, which most have the operating, so if they also have a debt service, between the two there'd be a net decrease because they're going to see a pretty good property tax drop on the debt service portion of it is. So, if you were to pick your school district representative, Erickson, if you kind of look at that where we got to the business tax impact on that $1 million business, if you looked at the first column, that's probably a tax increase, depending. But if you look at, and that would be operating referendum, but that they have a debt service, that's the fourth column.
Yes.
There, and I would think that, I don't know, but I would think there'd be a pretty good decrease there maybe. in your district, Chair Erickson.
Representative Erickson. Chair Erickson.
Well, Mr. Chair and Representative Marquardt, I wasn't concerned about my district.
Well, no,
My
I-
districts are okay in this, but, perhaps in the suburban area, I'm not sure because we never did have a huddle or a caucus discussion about this because it appeared that it would not pass out of education finance. So, that concerns me because the chair is expressing concern. And, I understand that there may be unintended consequences here. And cabin tax is seasonal rec, is that correct? That's just a common way of referring to seasonal rec. Because that seems to be on the plus side, advantageous to us when I look at the columns under cabin tax. So, Mr. Chair, I just needed, put on the record that Representative Loon still has concerns or has concerns. I don't know if she has seen this hypothetical printout or not, but just so that we're aware of that.
Thank you, Representative Erickson, and I can assure you she has, and I and others have walked through it with her. And Representative Erickson, my count of votes on the Education Committee was different than yours, or than what you may have heard. I think there was very strong support on the committee, and I think had we received a hearing, I think it would have passed. Anyway, questions? Representative Loeffler.
Well, thank you, Mr. Chair, and I understand the problem of school districts that have a lot of ag property and how they have unique issues, but this is a statewide change, and just roughly counting on the metro districts, it's basically half and half in terms of homeowners having increased bills and homeowners seeing decreased bills. I've got 24, if my counts are right, and I'm just quick trying to skim the charts. 24 would go down, and 22 homeowners would actually see increases under the simulations that were shown. And the businesses, and we haven't had any real discussion of why our commercial industrial property needs to be adjusted in this as well. Our businesses across the board, it looks like, get a big tax break after they got a big tax break passed into law last year with the state CI levy change. And so it's going to be hard to explain to homeowners why they're going to see increased school taxes when owners of cabins and owners of businesses are going to see major reductions. And that's because of the unique makeup of each geographic area. But in the metro area, we're going to have basically as many losers as winners on homeowners, and it's going to make it more difficult to pass referendums within the metro area because of the shifting that you're shifting onto homeowners. And so I would respectfully think that as we keep looking at this, we should look at, do we want to have this only apply to school districts with over X% of their tax base in ag land? What is the role of CI within this for communities that have a lot or a little? We haven't seen, how does that work? But I do think the shifting onto homeowners is going to be a concern in many communities. And that may have been Chair Lewin's concern, I'm not sure.
Thank you. And Representative Loeffler, I'll point out it's this table is important. If you look at it, that Representative Marquardt walked through, if the bill were passed into law, or if the amendment was passed into law as part of the tax bill, and your school district in 2022 had an existing operating referendum, then column 1 in each of those 4 areas would apply immediately. So for homeowners, they would immediately on July 1st of 2021 or 2022, whatever the date is in the bill, they would immediately see a tax cut. All the homeowners that have negative numbers in that column 1 under that first set of 4 columns there would see a property tax cut if they have an operating referendum in their school district. The column 4 in each of those sets of 4 would only apply if and after a construction levy passed the voters and the voters adopted it. So you and other members are not voting for something that's going to immediately and directly affect property taxpayers on the construction levy side. That's going to be a decision that the voters make only if they decide to do it in that district, if and when. But what you would even more directly have impact in is a tax cut for homeowners who have an operating levy going on in their district in 2022 when the proposal would be adopted, or when it would take effect. Representative Laughlin.
Well, thank you, Mr. Chair, and I think it's good to remind people that this is sort of long-term phased in, but the reality is the impact, time goes quickly. I can't believe I'm in my 14th year here. You know, time goes quickly, and all of a sudden you're there. And so I think we really need to weigh there as we're making decisions today. And I do think we should have some discussion about the business CI property and why that's included in this for a reduction when the homeowners are staying at the same rates. There's no change for them. So then they be not changing the homeowners. You make them absorb the benefits that are given to the other properties, including cabins, including commercial industrial, whether it's a small hardware store, it's a skyscraper, or whether it's, the ag land. And I understand the ag issues because Chair Marquardt, Representative Marquardt has given some really good examples that are compelling of areas that have a lot of ag land. But for the rest of us who don't have ag land, the fact that all the benefit goes to other types of property rather than homeowners will always, over time, make the homeowners share a bigger burden in this. And I'm not sure that that's the direction most people in non-ag districts would say we should go. And so I'm sympathetic to the issue of the burdens of areas with a lot of ag property. But I do worry that we are not providing any homeowner considerations in this to soften that impact.
Thank you. More discussion. Representative Anderson.
Thanks, Mr. Chair. And this is a lot to absorb here today. Obviously, it's a unique way to address the problem that we've seen in ag land, and over time, it would help that situation. And I have a concern. Has anybody taken into account? Representative Marquardt mentioned a lot of the rural bond issues have been defeated. With this type of change, any way to guesstimate if there's a rash of bond issues now in rural districts, and we'd have many, many more construction referendums passed, how would that change the dollar amounts needed to finance a bill like this? If you have, I say a rash, but many, many more building issues coming forward because of this change in how farmers aren't paying for most of the entire bill. Is there any thought to that? Is that a concern as we move ahead?
I will just say I don't think anybody knows. And we have to remember, too, that this moves it over to the referendum market value tax base, which the operating levies have been under for years. And I think Representative Marquardt pointed out the operating levies pass at a higher rate and have passed at a higher rate, much higher rate than construction levies. But then people will tell you, well, operating levies, many of them are simply renewals of existing ones, and those pass at extremely high rates to bring that average number up. So it's not real clear, and we don't even know how many levies are going to pass under the current system next year or the year after or 5 years from now. So it's very difficult to tell, but Representative Marquardt may have some comment.
Yeah, thank you, Mr. Chair, and Representative Anderson. Yeah, I do think it's tough to tell. Now, on that small school portion, in talking with folks, there might be a pent-up demand right now where there's a lot of these really small districts that just can't do it and yet their buildings are aging, but they financially can't do this. There could be, and so the $2 million that is kind of going to be nestled away in the bill, it may have to be more. That's a possibility because you just wouldn't know what the demand would be there. But on the debt service, and certainly this ag situation isn't the only reason. But on the debt service, when only 45% are passing in the rural versus 75, there's something going on there that is impacting things.
Representative Anderson, done? Any other questions, members, comments? Okay, hearing none, all in favor of the A8 amendment signify by saying aye.
Aye.
Opposed, no. Motion passes, A8 is adopted. Next amendment. Representative Hertaus?
Yep.
Representative Hertaus moves the A11 amendment. Representative Hertaus, does everybody have the A11 amendment?
Thank you, Mr. Chair. The A11 is in the packet. Members, there is a coalition of folks who are concerned about affordable food and the clarification of local taxation authority. This bill or this amendment seeks to clarify what is already existing law in Minnesota Statutes 477A and limits local units from imposing a tax on any item that falls under the definition of food or the containers that they come in. It's important to note right now that no local units of government in Minnesota have such a tax right now, and that there are cities across the country that have been under increasing pressure by outside interest groups to pushing additional taxes on product-specific items. And so what this bill would do is protect local officials from outside pressure groups in lobbying for taxes that have a questionable legal basis and could be opposed in court. So that's what this A11 amendment attempts to do, members.
Thank you. Questions for the author or other comments on the A11 amendment? Hearing none, all in favor of adopting the A11 amendment signify by saying aye. Opposed, no. Motion passes. A11 is adopted. Next amendment.
A20.
Representative Carlson, then we'll come back to her. Representative Carlson.
Thank you, Mr. Chair. This is, at the request of nonpartisan staff, this is House File 4218. This is the Bloomington TIF modification. Having had a chance to speak with many of you in the meantime, the issue was raised in terms of having kind of an end date for which the five-year extension could be tied to a specific date as opposed to just being exempted from that. So there's been a couple of suggestions that have been brought forth on this again, so I'm kind of shooting from the hip on this, and I don't have the language in front of you is the exact bill, which has the exemption. But if there's a willingness in which to amend this here right now, I could come to an agreement on what that might be, or if it's a matter of just bringing the amendment to taxes, I guess I would defer to the chair.
Okay, thank you, Representative Carlson. So Representative Carlson moves, do you move the adoption of House File 4218 as amendment, Representative Carlson?
Yes, Mr. Chair.
Okay, Representative Carlson moves adoption of House File 4218 as amendment to the bill. Discussion, members? House File 4218. Representative New.
Thank you, Mr. Chair and Representative Carlson. I think that I certainly, I speak for myself, I was a little unclear regarding the testimony on the bill at the time that it was given, and perhaps we could have asked more questions in committee at that time. But I am one who's not comfortable with removing the limitations at all, but I would certainly support a friendly amendment inserting a time limit for 5 or 10 years from today to give some additional time on that too.
Okay, I appreciate that. Thank you.
Okay, Representative Anderson.
Mr. Chair, thank you. Yeah, I think there was some lack of understanding when the bill first came up, and this is a big project, and I think also that in addition time, 20 years or whatever would be warranted to help this project move along.
Other discussion? Representative New, do you have an amendment? The amendment?
An oral amendment to the amendment? Is that what we're saying?
Mr. Clayman will help you, I think, maybe with the intent of your amendment to the amendment. Mr. Clayman? If you intend to amend the amendment. Rep.
Sure, I mean, I would move to, help me with the language, but I would move to extend the TIF for 10 years from today, or enactment of the TIF. Not enactment of the TIF, we don't want to go retroactively, but.
You want to extend the 5-year rule to, Representative, or Mr. Clayman will help you with that.
Mr. Chair, Representative New, so the House File 4218, if you sort of look at lines 1.11 and lines 1.12, the stricken language, there's a current 15-year extension of the 5-year rule under current law. So if the amendment is to, but as proposed, then it's to extend it, or it's to get rid of all limitations on the 5-year rule. So if you want to keep the 15-year existing limitation in place, then we can do an amendment for that, or it sounds like you want to take it to 10.
So no, I
No,
guess what
Representative.
we would be asking is that we'd be changing the 15 to a 20 or 25. Would that?
Representative Carlson.
Well, again, I do appreciate the discussion and the conversation around this, and the willingness to make this work. I think at this point, based on some of the side conversations we've been having here, it might be best if we just bring this amendment to taxes in good faith in terms of what's been said, so we're not having to undo something we do here, and by putting some guardrails around this, ensuring that we have adequate, I mean, again, this is a 50-acre site that has shown significant progress in terms of the development that's taking place, just allowing for enough time for that momentum in terms of the development that's occurring to continue and to finish up the way it's intended based on the Bloomington Master Plan. So I think I've got some good insights on how to do that, but would appreciate the opportunity to bring that amendment to taxes.
Okay, so Representative Carlson withdraws the House File 4218 as an amendment to the
Yes,
bill?
Mr. Chair.
Okay, thank you. Representative Loeffler.
Well, thank you, Mr. Chair and members. Just on the topic of local bills, I know you weren't available yesterday, but and we've done some fixing now. I appreciate your work, Representative Rarick, on the Mike Sundin proposal, and Representative Now, you're working with the Bloomington proposal. We have had other local proposals that came from our members who aren't on this committee who really would like to better understand if there's ways that they could make some adjustments as well and have them considered. So I just want to let you know and the members that we'd really like to hear your concerns to see if on some of the others where cities are waiting to make decisions about where they're going to go forward and how, to get the feedback from you on why some of these weren't included, or if we might be able to make some adjustments like we have on the two previous ones, just to make them better fit within the development framework that you're looking at.
Okay, thank you. Yeah, I mean, so for instance, this, I can just offer, I think there, I talked to some members about this particular proposal originally, and there was concern about just throwing the 5-year rule off completely, and it would create brand-new precedent, and Katie bar the door, and there you go. So that was kind of, I think, really kind of the alarming part about the construct of the bill. So Representative Carlson and Representative New, if you can work on this between now and taxes, I think that's a good approach. Okay.
Thank you, Mr. Chair.
Next amendment, A20, Representative Hertaus. Representative Hertaus moves the A20 amendment.
Thank you, Mr. Chair and members. The A20 amendment is House File 4434 that we heard this morning. Since that time, this has been turned into an amendment, and some of the issues that we discussed were changed, or just a few technical changes that we think could solve the problem. I would defer to Mr. Clemens if you'd like to explain what we did.
Thank you. Mr. Clayman, can you help us better understand the bill as it was presented this morning? I think this is the same language, is that correct?
Mr. Chair, so the A20 amendment is substantially similar to the bill that was heard in committee this morning. To recap what that bill did, there were 3 sections. The first section would have created a new subdivision in the Ag Homestead section that would have created a uniform requirement to calculate percentage ownership for fractional homesteads based on the deeded interest that an owner has of that homestead. And so all the only difference between the A20 amendment and the bill as it was heard this morning is that in sections 2 and 3 of the bill, instead of trying to build into those sections an idea of how to calculate the percentage ownership for purposes of dividing the homestead exclusion and the credit, there's just a simpler reference to the proposed new subdivision in section 1 of the bill. And I guess also just to clarify, the bill would create a default rule to calculate homestead based on deeded interest, but the sort of the plan B would be if you can't do the calculation based on deeded interest, then you'd fall back to the equal shares calculation, which would be the 100 divided by the number of owners calculation. So really the only substantive change in the amendment is just technical. It's just that creating that cross reference to the general proposed way of calculating the homestead.
Thank you. So, Mr. Clayman, kind of really the reciprocal to the approach we were talking this morning, the ownership, plugging the ownership percentages in those boxes that Ms. Geis talked about would be the default, and if that doesn't work, or would be the approach, and if that doesn't work, it would then default to the 100% divided by number of owners. Is that correct?
Mr. Chair, that's correct.
Okay, thank you. Discussion, members? Hearing none, all in favor of adopting the A20 amendment signify by saying aye.
Aye.
Opposed, no. Motion passes. A20 is adopted. Next amendment, anyone?
Last one is A16.
Representative Loeffler.
Well, thank you, Mr. Chair. While we're on local issues, I have an A13 amendment. And this is a bill that was heard in the division dealing with the Minneapolis lodging tax. And as you heard there, Minneapolis is actually has historically had a lower lodging tax than many comparable cities like Rochester, Bloomington, Duluth, and St. Paul. And but we have an unusual provision in law that was put in 1986, and nobody understands why, because there's not anyone hardly around. We've forgotten to ask Lyndon Carlson if he can remember why. But we're the only one that has this overall cap that forced a reduction in our lodging tax when Hennepin County took advantage of the state law and added a transportation tax. And that has forced Minneapolis to reduce its lodging tax in a totally unanticipated way by anyone who was involved, because this is this old 1986 law that everyone's not paying attention to always, but the Department of Revenue is. And so we just want to make it so that we're continue to maintain our historic level of the lodging tax as is authorized for every other city. And we went into more detail in the committee, and I'd be glad to answer questions, but just to bring your mind back to what the situation was, this is just to treat us like the other cities without an overall tax. We have to pay attention to every other decision that's made by other local governments or the state.
Okay, thank you. Representative Hertaus? Other discussion? No discussion. All in favor of adopting A13 amendment signify by saying aye.
Aye.
Opposed, no.
No.
Motion does not prevail. Okay, other amendments. Representative Joachim.
Thank you, Mr. Chair. Here, sorry. I have an A9 amendment that's being passed out, so I'll just wait a minute here.
Representative Joachim moves adoption of the A9 amendment. Representative Joachim.
Thank you. As it's being passed out, I'll chat about it here. Actually, it deletes a section on page 84. It's section 6 on page 84. It's actually the Mille Lacs provision of Representative Erickson's. And I have concerns about this, but I want you to know a little bit about my background too. I have grandparents that for decades had an ice fishing house up on Lake Mille Lacs, and uncles that then inherited it too. And I can still distinctly remember at about age 7 when we built a new upgraded fish house in their front yard to bring up to the lake with a window for my parents when they put a sliding glass door and they gave Grandma and Grandpa the window, and it was super fancy. It had bunk beds and was going to have 4 holes and even a couch in there. So I come from a family that does a lot of fishing, and we have a family member that's actually a sports fisherman too. And I've talked to him about the slot limits and stuff up on Lake Mille Lacs, and he actually, probably the only thing we do agree on is that the DNR has been managing it well. Otherwise, there's a lot of other policies we don't agree on. So I just want you to know a little bit where I'm coming from. My concern, though, too, is the precedent that this provision would set. It allows a city, or almost requires a city to do a tax abatement on property for a year, but then also to tax abatement on property, and then also to refund the portion of the state general levy for businesses that may have been harmed by what they perceive as the shortage of walleyes. I know on Mille Lacs, they've been doing a great business right now on bass fishing, and they've seen a huge increase on that. I know that from my sports fisherman relative. And while I do support bills like we've had before us on towns that are decimated by fire or tornadoes or things that are very more specific, this is really more, it's not very subjective. There is some provisions in here for a business to prove that they have a loss, but that can be very nebulous. And if you think about all the other areas of our state that rely on tourism and industries like this, would this lead to folks around the Brainerd area, if we don't have enough snow one year and they really see a downturn in their snowmobilers coming in and visiting their restaurants and staying in their lodging establishments? Or let's say, I know Lanesboro, they really, really rely on their bike trails in the summer. What happens if we have a summer where it's raining 4 times a week and you can't get the folks down there to really spend the money in the town? So I think this really opens a door to seeing a lot more of these up all around our state, and that really actually concerns me. So I would hope you would join me in removing this special exemption out of the underlying amendment. Thank you.
Thank you, Representative Joachim. Discussion on the amendment. Representative Lunan and then Rarick.
Thank you, Mr. Chairman. I suspect, I consider it different than the examples the representative just mentioned, in that I think up in the Mille Lacs area, some of the problems that exist have to do with the DNR's management of the resource, and so that the government does have some fingerprints on the problem. So I see this as very different.
Thank you, Representative Rarick.
Thank you, Mr. Chair. I want to echo that same thing. The examples that were brought up were weather-related. That's something that's beyond our control. This was something that was done, like I said, it was a mismanagement. I think, it was something that could have been handled and should have been handled differently. And I realize they're starting to change the way that the Mille Lacs people are coming up. They're using the lake with bass fishing and other things, but these people need some help because the damage was done prior, and it was done to them. Other people know when they're getting into an activity based upon weather that's a potential issue. This was not such the case.
Thank you, Representative Erickson.
Thank you, Mr. Chair. I'm sorry this occurred while I was out of the room, but this is something the governor has been advocating for, and so that's why I brought it forth. He met with Mille Lacs folks several weeks ago and said that he was very supportive of doing this. Yeah, I think it might set a precedent, but this is something the governor and the Department of Revenue have advocated since we had the working group when the lake was shut down. So that's the reason that I brought it forth again. Whether it survives, I don't know, but that's the reason I brought it forth, based on the governor's recommendation.
Thank you. Further discussion? All in favor of adopting the
Mr. Chair.
Oh, Representative
I was
Joachim,
hoping
sorry.
I could have the final word on my amendment. I do understand the concerns, and maybe I should have reached out to the governor's office. It was my assumption that they still were not comfortable with this, so I will withdraw the amendment. Thank you.
Okay, Representative Joachim withdraws the A9 amendment. Other amendments, members? Representative Lean.
Thank you, Mr. Chair. I do have an amendment here. I will hand it to staff to get it passed out. Thank you. And basically, this amendment is House File 3439, so I would move House File 3439 to be included in the division report as an amendment. Excuse me, 3493, House File 3493 into...
Representative Lean moves House File 3493. Representative Lean.
Hard to say, Mr. Chair. I hear you. Basically, this bill would appropriate $30.5 million into local government aid for calendar year 2019. We did do some work last session for local government aid, putting more funding into that program, and this would just be continuing in those efforts. We are in surplus years, and so I think it's important to continue funding for the local government aid program to just really to make sure that services across the state do come at an equitable price, continue to come at an equitable price, and also just to continue that relationship between the states and the cities. So I ask for your support, members.
Thank you. Discussion on the, on House File 3493 as amendment to the bill. Okay.
Mr. Chair, I would do request a roll call, too.
Roll call's been requested. Here, Representative Anderson.
Thanks, Mr. Chair. Just to, I obviously support the bill. Where is the funding going to come from, being we are, it's a stage where we don't have a lot of money to work with?
I had the same question, Representative Anderson.
Miss-
Representative Lean.
Thank you, Mr. Chair. As far as I know, this would be for payable calendar year 19, so this would be out into the tails. The last budget forecast does show a $313 million surplus for the next biennium. Also, just taking a look at the spreadsheet that was handed out today, there is about $7.3 million of spending in the tails in the current division report. So although 7.3 million does not equal 30.5 million, there is some precedent here, and just using the next budget forecast, we do see that there would be some money available for this.
Okay, further discussion, members? Okay, hearing none, the roll call has been requested. The clerk will call the roll on House File 3493 as an amendment. The chair recommends a no on this particular amendment. Clerk will take the roll.
Chair Drazkowski?
No.
Vice Chair Jerry Hurtas? Representative Loeffler?
Yes.
Representative Anderson?
Yes.
Representative Barr? Representative Carlson?
Yes.
Representative Erickson?
No.
Representative Frankie?
No.
Representative Lean?
Aye.
Representative Lunan? Representative Marquardt?
No.
Oh, Representative Marquardt?
Yes.
Representative Nelson?
Yes.
Representative New?
No.
Representative Rarick?
No.
Representative Whalen? No. Representative Joachim?
Yes.
There being 7 yes and 8 no, the amendment is not adopted. Next amendment, members. Representative Joachim, and then Loeffler.
Wait, don't get too many there. Here we go. Thank you, Mr. Chair, and this one's being passed out too. It's labeled the A7. I'd like to move the A7 amendment.
Representative Joachim moves the A7 amendment, adoption of the A7 amendment.
All right. so-
Representative Joachim.
Thank you, Mr. Chair. It's on, it deletes a section 9 on page 106. And this is a section that we've had quite a bit of testimony on, both on Wednesday or both on the day that it was introduced and then today, from League of Minnesota Cities, Metro Cities, Association of Metropolitan Counties, Intercounty Government Association, and Hennepin County. And folks are very concerned about the precedent that this would set, where you would allow cities to keep a portion of a county sales tax. So this is the transportation tax that the Hennepin County put on with a vote of their board, and after plenty of discussion and transparency, that they are implementing, that actually, once they left CTIB, all 87 counties can do this under statutory authority by the state. And it would allow, or would require Hennepin County to then take half of that sales tax, 50% of it, and remit it back to Maple Grove, the cities of Maple Grove and Plymouth, to do work in their county and county roads. Now, I understand sometimes the frustration between city and county government, and then also, obviously, the frustration between city and county government and state government, and so on up the food chain. But the precedent that this sets to allow specific cities to keep sales tax that another jurisdiction placed on with a vote is really a little disturbing, especially when it comes to counties having to do a lot of different work that either the state requires them to do or their region requires them to do. Things like road construction that go across city lines, and usually you can get a lot better deal when your project is longer, so going across city lines. So let's say Hennepin County had a project that's out 5 years, and Plymouth and Maple Grove wanted to do it next year, and they want to do just their section. Actually, the bang for their buck they're not going to get unless they're part of that regional plan. So I have a little concern on the cost to the taxpayers on that. And it, not just the raise in the cost, but the confusion of the responsibility of assets folks have seemed to be having around this. It's been stated very clearly that one of the bridges that the cities are the most concerned of is not county-owned. It's state-owned. So it seems to be there needs to be a lot more communication, and I do understand that. But I just want you to think about the precedents that this would set, not only about trampling on local control, once again, but also think about cities across the state that might say, you know what, hey, this sounds pretty good. I just want to keep my citywide sales tax. Think about counties that might want to do this. 65% of sales tax and tax within Hennepin County actually goes out to pave all your roads and all over the rest of Minnesota. So, you know, you don't want Hennepin County to go, hey, what's mine is mine and I'm going to keep it. So just think about the precedent this sets, and please vote yes on the removal of this provision. Thank you.
Thank you. Discussion on the A7 amendment. Representative Nelson.
Thank you, Mr. Chair. And as Commissioner Carlson pointed out earlier, Hennepin County would love to keep all their sales tax that's generated in Hennepin County because we could do a lot of stuff with that there. But the other piece of this, my district butts right up against Maple Grove, which this would benefit. And a lot of my residents, because of the retail that's in Maple Grove, we don't have some of those stores in Brooklyn Park. We go over there and use their stores. So they're basically going to take my sales tax that I pay and use it in their city, and they're going to short what I get in Brooklyn Park and what we get in every other city in Hennepin County. This is, like I said, this is a bad precedent for us to start, because what's going to stop Bloomington saying we want to keep all our sales tax? Mall of America generates, I don't know how much they do, but they probably generate a large chunk of sales tax in Hennepin, or at the Mall of America. We want to keep all ours if you're in Maple Grove, or if you're in Bloomington. And again, the amount of taxes that are generated, I've heard different numbers between 67 to 70% of the taxes collected in the state of Minnesota are collected in Hennepin County. So what if Hennepin County keeps all their sales tax and all the taxes they generate in their county? That's going to affect the local government aid all over the state. All the cities that get local government aid, there's not going to be the pool there, because Hennepin County is going to keep it and spend it in Hennepin County. This is kind of a bad precedent for us to set. It's looking at one little piece and saying we're more special than everybody else. We should be looking out for the whole state. We're one state, and we need to make sure that we have vibrant communities and good roads and good schools throughout the state of Minnesota, and not just in two little cities.
Thank you. Other discussion on A7? Okay, hearing no discussion, all in favor of adopting the A7 amendment signify by saying aye.
Aye.
Opposed, no? No. Motion does not prevail. A7 is not adopted. Next amendment, Representative Loeffler.
Thank you, Mr. Chair, and this is the A17 amendment. And we heard this in the Property Tax Division on Monday when you weren't here, but I appreciate you being an author on my bill to preserve the status quo. And this is where our current property tax refund statutes refer to provisions in the federal tax law that no longer exist with the changes in the federal tax bill. And related to dependents, seniors, and people with disabilities. And so we asked House Research to, as much as possible, maintain our property tax refunds programs the way they exactly are right now. And so the House Research staff came up with language that brings back in the concept of specific dollar amounts rather than referring to federal exemptions. And the fiscal note that we got on this was 0, because which I thought was a nice reinforcement that this is just replicating what we have right now.
A conservative bill, Representative Loeffler.
But if we didn't pass this and adopt it, almost 500,000 people would have their property taxes either disappear or be reduced, and have about $84 million less in property tax relief.
Okay, thank you. Discussion on the A17. Representative Loeffler, I do understand Representative Davids has this covered in his tax bill. I don't know how we proceed. I think most people want to make certain that we protect the ability for the PTR to work properly. But I understand he's going to, in the construction of his tax bill, take care of this. So I don't know how to proceed. How would you like to proceed? Representative Loeffler.
Well, thank you, Mr. Chair. Since our property tax division report usually gets melded into that bill, I don't think there's a problem with adopting it. But there was some confusion. I had talked to Chair Davids about who I should even ask for the hearing request, and he suggested that I ask for it within your division. So that's why I'm pursuing it in the division here.
Okay, thank you. Other discussion on the amendment? And members, it may not be, if we can have Chair Davids kind of, as you suggested, Representative Loeffler, if we put this on, work with it. If he doesn't need it, he'll remove that language or make the changes. This way, at least we got a placeholder, so I don't see a problem with that, members. Does anybody else see any issues or further discussion on the amendment? Okay. All in favor of adopting the A17 amendment signify by saying aye.
Aye.
Opposed, no. Motion passes. A17 is adopted.
Thank you.
Thank you. Next amendment, members.
Mr. Chair?
Representative Loeffler.
I can bring another one forward, and this is an A14 amendment. It's a new concept, although I've had a chance to talk with many members of the committee and the chair about it over time. And that is the issue of committees, other committees, making decisions that impact the property tax bills that our committee has to deal with and property tax burdens. And you might recall in special session 2 or 3, I'm not sure which it was last year, one of those middle of the night situations, a new concept was put into law that said that counties statewide would have to absorb $20 million of the cost of the Min Choices assessments. These are the required mandated assessments of any person who is elderly or disabled who is looking for home care assistance, help with their disabilities, help with medication management, so that we establish that they truly do have a need and what that level of need is. So it's a mandated protection for getting people into the programs who need it, but not people who don't. And so it was an example of how in the middle of the night, without a bill, without a hearing, a property tax burden is put on all the counties, and it's a mandated service with no revenue source, so there's the only place they can turn to is property taxes. As drafted, this is a county human service aid, which would only be applicable to specific mandates that for which The Committee of Jurisdiction has not designated another funding source, and it just allocates $20 million and divides it by the number of assessments that each county has done. So one county's done 100, and then the next door county's done 120. They each get the same amount per assessment. And it's a way for our committee to start to adjust for raising property taxes that comes about because of decisions in other committees and other places. And thought I'd introduce this as a point of discussion because I think it's an approach that we should think about taking because the easiest way for another committee to adjust its budget is just cost shift onto property taxes in many situations. And this is a way to say we want to provide some property tax relief for these mandated services that the county boards have no choice on. They have to provide these services.
Okay, Representative Loeffler moves the A14 amendment then. Discussion on the A14 amendment. I will offer one thing, members. We don't have a spending target in this committee. We don't have a positive spending target. So we did come forward with cuts in our bill, which is good, but we don't have a spending target. This would be a net spending target in the bill, so I think it'd be problematic. But I think the discussion is a good one. Representative Lunan, did you have discussion or anyone? Okay. Any other discussion? Okay. All in favor of the A14 amendment signify by saying aye.
Aye.
Opposed, no. No. Motion does not pass. The A14 is not adopted. Next amendment. Representative Joachim?
Okay.
Representative Loeffler?
Yeah, sure. This is the A5 amendment. And Mr. Chair, you are very consistent, but we saw something in the bill that we hadn't heard and that we're not sure is under our jurisdiction because it doesn't deal with local government finances or property taxes, and that's the political contribution refund. And the bill before us, as amended by the chair, would eliminate that program, which was just reinstated last July. And this would delete those provisions so that the program would continue. And I feel, not only do I think there's a question as whether this is our jurisdiction versus the full tax committee, because it isn't local government finance. It's really about the state's situation. But it also, I think, is one of the major equalizers that we have in terms of allowing the average citizen who lives paycheck to paycheck, who doesn't have a whole lot of extra money, to participate in democracy in a way that's meaningful to them and that's meaningful to their ability to participate, as well as to empower candidates who do not have, lots of wealthy donors, lots of wealthy neighbors, and who want to be dependent in running the races on the ordinary citizen. For those of you who might be watching on TV who don't know what this program is, it allows any individual in Minnesota, a voter, to give up to $50 and get it refunded through this program if they give it to a state-level candidate. And it has proven to be a way of engaging other people in. I'm always surprised when you bring it forward because your party is so much more successful, Mr. Chair, than the party that I'm in getting people to participate in this program and step up with their $5 or $10 or whatever to support democracy and to support a candidate they really believe in. And I think that this should be a source of pride for all of us that we have a state that values citizen participation and engagement. And I think that we ought to be most accountable to the people that we represent who live in our districts. And this is a way to help assure that that's true, whether you live in a district of wealthy people or you live in a district where people really, there's a lot of seniors, a lot of people on fixed incomes. My favorite donor, she has since passed away, so I can call her that without offending anyone else. My favorite donor was a retired woman who would, on an unequal basis, once in a while send me $5. And then she'd And she'd say, don't bother with those receipts until the end. And I'd say, well, no, we have a process. We have to keep doing this. And so we'd send her the receipt for the $5. And then later in the fall, she would say, okay, it's time to send me that form I send in, because this was her Christmas savings program. And so when she had an extra few dollars, she'd send it my way, and then she'd turn it in, and the refund would come in time for her to use it for holiday expenses. And I just thought that was charming, and I know how much every dollar was important to her, and I think that she's a model of the kind of person who might get engaged in our democracy and our democratic processes that wouldn't without this kind of a program, because they're just living that close to the edge.
Okay, Representative Loeffler moves the A5 amendment. And Representative Loeffler, I'm pretty sure that this is under our jurisdiction, the political contribution refund. Can you confirm that, Ms. Schill? Is PCR under our division?
Mr. Chair and members, I distributed 2 spreadsheets to you, one the first week that we met, and the most recent with the governor's budget recommendations on March 21st, and it is line 7. We take care of all refunds, including property tax refund, political contribution refund, and actually tax refund interest.
Okay, thank you. Without me going on my political welfare discussion, members, do you have any discussion on this amendment? Okay, all in favor of adopting the A5 amendment signify by saying aye. Aye. Opposed, no. Motion does not prevail, and the A5 is not adopted. Next amendment, members. Representative Youakim.
Thank you, Mr. Chair, and this is the A6, and promise we'll get out of here soon. I've got a daughter to pick up at the airport. So this is the A6 amendment as it's being passed out, and this is dealing with the provision we've probably heard the most testimony about. Definitely heard some very compelling testimony on Wednesday when the bill was first introduced. And we heard folks come up today, including even the Department of Revenue, saying that this isn't the best idea. This amendment removes a section on local government aid and county program aid regarding legal aid in sanctuary cities. I really don't think this is the right way for Minnesota to go. I know that the authors tweaked some of the language in the final version, but I still have grave concern for the direction this provision would take us. And as we've heard from quite a few lawyers, that this could really open us up as a state to costly lawsuits. It is overly broad in defining what could qualify as a sanctuary city. The way it's drafted, you could have an overzealous city employee ask a resident about their status when they come in to do something as simple at City Hall as asking for a fence permit. You could have a city administrator trying to do their job well, simply give direction and a policy to stop doing that, and then that city or town could then be labeled as a sanctuary city. This amendment is also about local control. Our cities and towns are tasked to protect the health, safety, and well-being of the residents, and this bill makes it much harder for them to do that. It makes our law enforcement, our first responders, and our cops' jobs harder. I wish we could have had the testimony of the officer that was going to come down from St. Paul to talk about that. But really, the bottom line for this is that local government aid and county program aid is a property tax relief program. It makes sure that every resident in Minnesota has a basic quality of life that they can expect and depend on. Things like being able to flush a toilet, drive on a street, call 911 or call someone to help them. So no matter where you live, that these things are provided to you. LGA and CPA is set by a formula that a lot of folks have worked on and agreed to, and this provision completely ignores that formula. And finally, LGA and CPA should not or never be used as a stick to beat a city or a town or county into submitting to a political, dogmatic view of the world. There are so very many reasons to vote yes on this amendment to remove this language. So let's just vote yes on this amendment and move on. Thank you.
Representative Youakim moves adoption of the A6 amendment.
Yeah, and sir, Mr. Chair, I also would like to ask for a roll call.
And she asks for a roll call. A roll call will be held. Discussion on the A6 amendment. Representative Lunan.
Thank you, Mr. Chairman. When we heard this bill earlier, the term local control came up, and I had gave this speech then, I'm going to give now. Local control is what, in my district, I got feedback on this strongly, that there are people that aren't interested or are not happy to fund other entities that basically defy the law of the land. This bill doesn't say that those cities can't do that. It's that you're going to do it on your dime. You're not going to do it on my district's dime. I consider this bill more of a local control provision than everybody gets to do what they want. No one incurs any consequences directly. It all gets spread out over everyone. And decisions have consequences. And that's what this provision does. So I ask for a no vote.
Thank you. Other discussion, Representative Loeffler.
Well, thank you, Mr. Chair, and it goes far beyond taking away the money of this cost. It actually eliminates your local government aid, which is a pretty high price to pay for an investment that's responding to your citizens and your residents and taxpayers. And I would remind you that we heard compelling testimony yesterday that most of these people are taxpayers. They are contributing to our city. They are paying property taxes, many of them, and directly or indirectly through their rent. They are their children are in our schools. Most of these families are mixed. And this is assisting people in understanding their rights. Immigration law is very complicated. We heard how there's 43 different types of visas. There's all kinds of different complications that I won't pretend to understand totally, but people have very different statuses. It's not just gray. We heard testimony that 60% of the people who are brought to court with an attorney for this are not deported. The courts say, oops, sorry, you get to stay. You think of the identity theft that they say that all of us probably at some point in our life will be a victim of identity theft. That happens whether your name sounds like your ancestors came from a foreign country or not. And so the mistakes are made. Interpretation of law has to be made. And this allows our American system of justice to go forward with people knowing what their rights are and to have a chance to say, you've made a mistake, Your Honor. Here's my proof. Here's the information. And it also allows our cities to say, we have thousands of employees, and this is what your job and your job responsibilities are. You heard our lobbyists read, and I could read it again, the provision in the Minneapolis provision that says that nothing in their ordinance prohibits them. In fact, they are expected to work to provide legal information when it is requested. But they do not want every city employee to think it's their job to inquire about citizenship. And so I think there's a lot of misunderstanding in this area. And I think that the testimony that we've heard is pretty compelling. It's like in any system, people should have the right to be able to seek help if they're the victim of a crime and be encouraged to do that, to feel comfortable coming forward as a witness so that we can identify and arrest perpetrators and get them prosecuted without fear, that they can reach out for domestic abuse services without concern, and yet at the same time be accountable to our court system when the court system has concerns. And we have a country that generally believes you're innocent until proven guilty. This is in the county situation, a chance to let them present their case. And we heard compelling testimony that oftentimes the court, which knows these federal complicated laws in a way I never will, that the court makes a decision in the favor of the person in front of them. And I think my local governments are doing the right thing and stepping up to make sure that everyone gets fair treatment. And they're not asking you or anyone else to do that. Our local government aid factors are all based on measures that are out of the control of the city, that are basically about need, that we all agreed on a bipartisan basis and a pretty amazing process a few years ago. And we've heard from the city organizations that they really don't want us to start using this program for other purposes.
Representative Lonan.
Thank you, Mr. Chairman. This provision they're trying to remove, members, isn't about whether cities should be doing that, whether them doing it is a good thing or not, and that isn't, my position doesn't fall that way either. This is about who should be paying for it. That's what we're voting on.
Representative Anderson.
Thanks, Mr. Chair. If the chair would, could I ask Representative Loeffler a question?
Certainly.
Representative, you talked about certain city employees not inquiring about the status. Do you believe our city's police officers should inquire about the status of folks?
Representative Loeffler.
Mr. Chair and Representative Anderson, not on a routine basis when they're dealing with a victim who's just reported a rape. I don't think that's the first question you ask. I think you ask, how can I help you? Who was the person? Which direction did they go when you were robbed at gunpoint? That's the first questions that a police officer would ask. I'm sure that, but that doesn't, the city ordinance, as I saw, and like I said, I can look it up in my files here, does not say that they cannot ask that when it's appropriate and when there's an ICE investigation or other things going on. But quite honestly, if you've read the headlines and heard from our new mayor, our police department right now are just scrambling from one 9/11 call to another. And part of our new mayor's thing is like, how can we have community policing where people feel comfortable and they know the cops if they don't even hardly have time to take the report before the next call is coming in? And I've heard complaints from my neighbors about how long it takes to get a response to a 9/11 call. Our population is aging. We're having a lot more medical emergencies than we used to have. And so it's about prioritizing which city employees should do what. And our officers on the street, their job is to say, did something happen? Get the information so they can investigate it, make sure that the victims' needs are met, whether that's calling an ambulance or whatever, identifying the witnesses in the area. It's the people who are on the next stages of the process, the investigators and others who deal with other issues. And so I think it really is about allowing a city to create job descriptions that says this is your job and that's not your job. I think of the situation we had in the state where we found a Department of Natural Resources employee who had access to the driver's licenses, and for whatever reason, he thought it was really fun to look up everybody's driver's license on a database. We don't want employees thinking that their job isn't, that they just get to define their job whatever the way they want. They all have a job description and are told, and there are people who have responsibilities of working with ICE, and there's people who don't.
Representative Anderson. More discussion, members. Representative Joachim.
Thank you, Mr. Chair. And in all due respect, Representative Lunan, I'm not a lawyer, and I know a lot of us try to play lawyers on TV, but we had a lawyer up here saying this is not in direct, this language is in direct contradiction to the law of the land. So you talked about the law of the land, and the immigration lawyer went through very specifically what is criminal law and what's civil law and how that's applied to. So we definitely disagree on that. We also heard a lot from the lawyers about the continued litigation across the country around the definition in terms of sanctuary cities. So my concern too is that we're opening up our state to a very large lawsuit. And we talk about, and I appreciate the fact that you are worried about how taxpayer dollars are spent. I am too. But we also heard that maybe this isn't the best tool to do that. There's formulas that LGA and CPA and Township Aid, they're very specific formulas that folks have worked along for quite a few years about how this program's dispersed. And there are some cities in our state that receive a ton of local government aid. We heard testimony when we talked about from the city of Morris, and we have cities that receive very little, but we also have cities that receive none. So the way this bill is drafted, it's treating cities that receive aid and cities that don't receive aid completely different. So if you want to have something like this put in place, maybe we should be looking at how we can treat all cities the same then. I'm saying that local government aid and county program aid, removing that from cities is not the best way to do what some folks, I believe, are trying to do with this bill. And we can go down the philosophical discussion about whether or not every single person that working at City Hall should be asking people about immigration status, but this is the tax committee, property tax committee. So I'd like to focus on LGA and CPA. And when you look at just that, we're not creating a level playing field for our citizen. And there are a lot of other reasons you could be voting yes on this bill. Or voting no on removing this provision. I said that wrong, sorry. There are a lot of reasons why you should be voting yes on this amendment to remove this provision. I can only think of one or two where people would be voting no. So I would please ask you to join me in voting yes. Thank you.
Discussion on the A6 amendment. Hearing none, the chair does recommend a no vote. The clerk will take a roll.
Chair Drazkowski?
No.
Vice Chair Hertaus?
No.
Representative Loeffler?
Yes.
Representative Anderson?
No.
Representative Barr? Representative Carlson?
Yes.
Representative Erickson?
No.
Representative Frankie?
No.
Representative Lean?
Aye.
Representative Lunan? Representative Marquardt?
No.
Representative Nelson?
Yes.
Representative New?
No.
Representative Rarick?
No.
Representative Whalen?
No.
Representative Joachim?
Yes.
There being 5 yes and 10 no, the amendment is not adopted. Further amendments, members. Representative Whalen.
Thank you, Mr. Chair. I have an amendment that I just would like to quickly speak to and ask Steve Hines to speak a little bit to, that would phase out disparity reduction aid, which is a really unique program that, in my view, is something that we could simplify our overall property tax system by getting rid of. And so the pages are handing that out along with a table, House research prepared. And then, again, I'll just ask our nonpartisan staff to walk through it, as they've been incredibly helpful in just preparing this. I don't plan to have a vote on this, Mr. Chair. I wanted to bring the committee's attention to it, as it was something that was brought up a few weeks ago in one of our other committee hearings. And I think it's a worthwhile discussion.
Representative Whalen, did you want to turn it over to Mr. Hines? Mr. Hines, whenever you're ready, they're still passing the information out.
Mr. Chairman, Representative Whalen, the bill, or the amendment that's being distributed would phase out disparity reduction aid over about a 5-year period, with the first year being taking it away, an across-the-board cut based on each jurisdiction or each area losing 3% of tax capacity is worth of disparity aid, and then after that, a phase-out of 25% a year for what was remaining. So just a little background is that the disparity reduction aid is unique in our system, in that rather than the aid amounts being determined to individual taxing jurisdictions such as school districts, counties, cities, towns, it goes instead to geographic areas that are a combination of those different, that have some geographically are in the same school district, county, township, et cetera. And the basis for the aid amount that you get was how much your tax rate for each of these areas was in 1989. And the dollar amount that you needed in that year to get you down to a standardized tax rate, at that time 100% of tax capacity, was the amount that you being these taxpayers would get in perpetuity to reduce their taxes each year by that amount. So there's no needs factor other than this, how much your tax rate was in that year, and there's no ability to pay changes that are taken into account each year. This program kind of has just gone merrily along. It has been reduced. It's about an $18 million a year program now and has been for quite some time. The first year was actually $60 million. I think the second year it was in the 40s. At one point, we took all the money that was going to cities under this program and moved it instead into the local government aid program. So that was one of the big factors in getting it down to its current level of 18 million. But the remaining part, and about roughly half of it goes to the counties and half of it goes to school districts, is still based on this 1989 allocation or circumstances. The little table that you have kind of gives a few statistics about the money, about how much tax rate reduction you get from the disparity aid. We found that in the highest unique area that got disparity aid is a reduction of 52% of their tax capacity rate. The average rate is around probably 110, so just to put it in perspective. If you look at the bottom of that sheet of paper, you'll see that many unique taxing areas get amounts of aid that are only reduce their tax rate by 1% or 3% or 5%. So there's not really making a big impact on their taxes. It's just some amount that's carried each year that gives them a little bit of a reduction. There are, however, a few places that do get these big reductions, like the one that gets a 52% tax reduction, 6 of them that get more than a 25%, and et cetera. So it's kind of a program that maybe needs some attention. It's been overlooked many times in the past, and Representative Whalen wanted to talk about it a little.
Thank you, Mr. Hines. Members, questions, discussion about disparity reduction aid and the amendment? And Representative Whalen, you did not move the amendment, don't plan to at this point, but simply discuss it. Is that correct? Okay. Members, any other discussion that you'd like to bring forward? Certainly an area, members, that we don't know a lot about. Many of us don't. I don't, and I'm learning. So thank you, Representative Whalen, for that, and Mr. Hines for your help in help bringing this forward so that we can start to get an impression of what this program is and what it means and where it goes and what its history is. So I think that's helpful, and really certainly I agree with you, Representative Whalen. Could use us kind of going over with a magnifying glass next time. And sorry you won't be here, it'll be certainly a loss to the institution and the Property Tax Committee and all your work, Representative Whalen. So thank you for that. Members, any other discussion on this item before we move to the next? Okay, thank you, Representative Whalen. Any other amendments, members? Okay, any final discussions on the bill as amended? Okay, well, hearing that, the chair renews his motion that House File 465 House File 465 as amended is adopted and referred to the Taxes Committee. All in favor signify by saying aye. Aye. Opposed, no. No. Motion passes. The bill is amended or is adopted as amended. Okay, with that, we're about ready to adjourn, members. This is our last meeting unless something comes up and we need to, maybe generate some more savings and get rid of the disparity reduction aid or something. But I want to thank all the staff that have helped us this year. We look around the table here, Mr. Hassick for your help, Mr. Knese for your help, Ms. Schill, keeping our numbers straight and reminding us what's under the jurisdiction of this committee. Thank you. Ms. Dalton for helping us get our bills in order and all of your inspiration and wisdom, and Mr. Hines for helping us understand things that are so complex that we never thought we could attain an understanding of them, but you're bringing us there. Mr. Clayman, thank you. Mr. Clayman, by the way, I've noticed in the last year working with you, you're picking this stuff up really fast, and you're up into third gear, not a second gear. So, thank you for all your help. Mr. Michael Mr. Michael is not here. Jared Swenson, is Jared here? Jared, thank you, and look forward to working with you more the rest of the year. And who else did we forget? Mr. Cummings, thank you for all your efforts, and I'm sure we'll be hearing about your resourcefulness as we move forward. Yes, you will. Thank you, Mr. Cummings. Mr. Williams, is he here? Thank him for his help. Travis Reese, Mr. Reese, thank you for your help. Cynthia is here. Wave your hand, Cynthia. Thank you for helping keep Miss Schill in order, and for all of your work. And Mr. Rubis, thank you for all of your efforts. Members, who did I forget? Our pages. Matthias, raise your hand. Thank you for your efforts. And do we have any other pages? Matthias handles it all, right? And, we got, what's this girl? Anna? Santa, thank you for your help. Okay. Yeah, you, excellent work. Excellent work, Santa. Okay, who did we forget? Anybody? Well, with that, members, thank you so much for everything. It's been a pleasure working with you, and we'll work together as we get through the end of the session and get tax conformity accomplished. With that, members, the meeting's adjourned.